Excellency. Good morning or good afternoon all. This appeal hearing is in the matter of CA 003 2026 and is being held by way of video conferencing before His Excellency Chief Justice Wayne Martin, His Excellency Justice Sir Peter Gross, and His Excellency Justice Patrick Anthony Keane, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the Registrar in Dubai on the judge's instructions. The claimant is represented by Clyde & Co. Lead counsel is Mr. Nicholas Craig, KC. The defendant is represented by Pinsent Masons. Lead counsel is Mr. Alex Potts, KC. Thank you.
Thank you. Mr. Craig.
Thank you, Your Honour. Your Honour, but before I begin, we proposed a timetable, if you like, for the purpose.
Yes.
I'm hopeful that is you're content with that suggestion.
Yes, we are, Mr. Craig. I asked the court to tell that, but you may not have seen the email. That's fine. I mean, you shouldn't feel obliged to use all the time that you have available, but that order is fine.
I'm grateful. Thank you. As you know, this is an appeal from a decision of His Excellency Justice Michael Black, and there is also an appeal by Oris from that decision. And I hope you don't mind if I use the expressions Abnick and Oris for the purposes of this, because otherwise, if we get into appellant and respondent, we're going to be in some difficulty.
That's most convenient, Mr. Craig, and I propose to do the same. So,
thank you. Very briefly, if I may, I'm just going to deal with the background, which you're probably fully apprised of already, but it seems to be sensible just to set that out. Abnick is an. Sorry.
No, it's not on it.
Somebody's talking. If you're not counsel or a judge, I wonder if you could turn your microphone off. All right. Thank you, Mr. Craig. Mr. Craig, before you go any further, you can assume that all members of the court are familiar with the context of the case. We've all read the skeleton arguments. We've read the judgment below. We've read the key evidentiary materials referred to in the skeleton arguments. But if that helps.
If you would prefer, I'm happy then just to jump straight to our grounds of appeal.
Yes, well, the first question I'd like to know is what's happening in Sharjah. We got evidence on the 30th of April, but we've heard nothing since then. Has there been an appeal from the decision of the Court of Appeal?
There has not been an appeal, but what we did do is we wrote to Horizon on the 6th of June, asking them to confirm that was, as it were, the end of the matter, but we haven't had any response to that. Now, that document, I'm just trying to find my reference, apologies for a moment, is at 1613 of the bundle.
Let me just find that. Thank you.
And if I could just ask you to look at that letter.
Well, there was a period, presumably there's a period within which an appeal had to be lodged.
There was.
And that period's expired.
That period has expired.
More than a month ago.
It has.
So there are no extant proceedings in Sharjah.
There are no extant, well, we don't know what position Horizon necessarily will adopt. Obviously, the key for us is it has not confirmed, first of all, that it has no intention of pursuing other avenues, for example, or abandoning entirely these proceedings. And given the way in which
it has in effect abandoned them by not lodging an appeal within time, hasn't it?
Well, yes, in that sense, but given the way in which they have behaved throughout, we're just not sure necessarily that is finally the end of the matter.
Well, it's starting to get a bit tenuous, really, isn't it, when there are no extant proceedings? But anyway, there it is.
Yes. So anyway, that's where we are with them. I mean,
yeah.
And I can't say anything more on that head than what is said in that letter.
Would you accept that if they had written back and said we are not pursuing any further claim in the Sharjah courts, the only issue left in the case would be the appeal against the decision that there was an implied term for reimbursement of legal costs?
I think, yes, that would be right.
Yes, all right.
I mean, as I say, the only potential issue is, as I say, whether they may bring proceedings in another court in Sharjah, because of course they're incorporated in Dubai, and there's no certainty, if you like, that they might not potentially bring proceedings in another emirate in the UAE. Alternatively, bearing in mind that the owner of this vessel is Liberian, it's a Liberian flagged, and the Liberian company, which is a subsidiary of Horizon, there's no certainty that proceedings might not be brought in another jurisdiction. So that is the concern.
Sorry, where?
Where might they be brought?
Yes.
Well, it might be
Realistically.
the most likely is probably Dubai, because that is where Horizon is registered. But it seems to me a possibility that they might seek, for example, to bring, I don't know, in Liberia.
I haven't seen proceedings in Liberia for many years.
No.
It's a nameplate.
Yes, absolutely.
But so just remind me, what was there have, of course, been proceedings between Horizon and ABNIC in this court, in the DISC court. And was that within the court's exclusive jurisdiction?
No.
It wasn't. All right.
No, it's not the exclusive jurisdiction. It was within, which is why the other proceedings could continue. And just to be clear in relation to those proceedings, I mean, at the time of the judgment, you'll recall that there was a short after the trial, but before the judgment was issued, the Sharjah Court of First Instance dismissed the claim by Horizon. But then in September last year, the Court of Appeal in Sharjah allowed the appeal by Horizon from that decision. So when the judge said in his judgment, we don't know what's going to happen in Sharjah, well, it was precisely the contingency about which we were concerned, namely that there was going to be a potential liability finding. Now, the reference for that is at the judgment itself starts at page 499, and the decision on that appeal is at page 506.
Yeah, but at all events, on the face of things, there are no current pending proceedings in Sharjah.
Correct.
Yes, thank you.
So with that, as it were, introduction, I want to, if I may, turn first of all to ground of appeal 3, which is essentially the question of what were the terms of the reinsurance contract, and in particular, whether or not there was incorporated into the contracts a follow the settlements clause. The judge held at paragraph 122 of the judgment at page 115 that the reinsurance contract did not contain the terms of the slip. And we consider that he was obviously wrong to do so, and in any event was wrong to do so, which in light of the decision drawn to our attention on Friday in Crystal Financial Consultants LLC is all that we need to establish.
Well, I think in Crystal terms, I think it's one of those decisions that in respect of which a trial judge has no particular advantage. There wasn't any material oral evidence given to this, was it? The sequence of events is not in contest.
Correct. Yes. So if I may just look at the relevant documents first. So it's effectively the exchanges which make up the reinsurance contracts, and then explain why we consider the judge to have been wrong. As regards the terms of those contracts, it's necessary to go back to May 2015 when the reinsurance was first placed with Auris, and you will see at page 837 of the bundle.
Yes.
This is 26th of May 2015, when ABNIC write to Auris and saying they've received a firm order from our client to ensure his marine hull war and P&I policy, these to which are as per the attached underwriting information, need kindly to confirm your 100% faculty to support at a highest commission possible. So in that context, the commission is obviously the payment that is going to be paid to ABNIC out of the total premium. So ABNIC is essentially entirely fronting the risk. And at page 838, the next page, you will see a response almost immediately from Auris, where it confirms the 100% FAT cover as per terms submitted, commission at 20%, and asks to advise the attachment date and confirm to bind cover. Then at page 839, you will see that ABNIC writes back on the 31st of May to say, pleased to confirm your 100% share, period of insurance 12 months, awaiting your cover notes. And then you will see on the 31st of May at 12:36, Auris write back to say, thanks, cover bound with effect from 10th of June, await closings, cover note will be sent to you soonest. So there is an expectation, just in relation to that await closings, that ABNIC will provide a closing document. In other words, a formal record of the reinsurance contract. Now, the cover note is at page 848. And you will see that it sets out the various terms of the underlying insurance and then provides on the second page 849 rate as per attached schedule, and then commission 20% inclusive tax. The schedule is at page 850, which calculates the premium in US dollars. And this document is signed by both parties. It's undated, but at the same time as this document is issued, at page 842, you will see the slip dated the 8th of June, and you will see underneath the heading, it says, Dear Sirs, with reference to our prior agreement, we confirm the following FAC reinsurance placement with you. And then it sets out insured, period, the sum insured, etc., the location of the risk, details of the cover, the rate, reinsurance share, reinsurance premium, reinsurance commission, and then it provides warranted all terms and conditions as per original policy, FAC reinsurers to follow all decisions agreed between the ceding company and the insured in regard to all terms, conditions, etc. FAC reinsurers shall also follow in every respect all settlements agreed between the ceding company and the insured. Kindly return a copy hereof stamped and signed in token of your acceptance for our records. In addition, on the same day, at page 840, you will see the credit note, which was issued by ABNIC to Auris in respect of the premium, because of course ABNIC was receiving the premium from Horizon, and then it was paying the entirety of the premium on to Auris less the commission.
Sorry, Mr. Craig, I can't find the note on the date on the cover note. Can you help me with that?
There is no date on the cover note.
There's no date on the, so we don't know when that was issued.
No.
Okay, thank you.
In my submission, this is effectively it's a bundle of documents, if you like, that were issued at about the same time.
So sorry, what was the date of the earlier emails there at 837? That were
31st of May is the last one.
All right. So it all happened within a week or so.
Yes. Yes.
Yeah.
Mr. Craig, you mentioned fronting.
Yes.
But although this is 100% reinsurance, and therefore in practical terms, it might be similar to fronting. There's no evidence, is there, of this being a fronting arrangement, or am I
No.
wrong?
No, you're right.
No. It's simply,
Yes.
it's 100% reinsurance.
Yes, absolutely. It's not a case where the insured went first to the reinsurers and then the insurers replaced it. No, it's not that.
No. Thank you very much.
Yes. In 2016, the underlying insurance was renewed, and so was the reinsurance. At page 853, you will see the request by Abnick at the bottom of the page. This is 22nd of June 2016. Abnick writes to say, we hereby confirm coverage hereon is to continue for the second year from the 10th of June without interruption. Final confirmation for your existing share. Our formal closing will follow shortly. Meanwhile, please confirm your share to enable us to proceed.
So where are you reading from now? Oh, yes.
It's at the bottom.
Final comment. Formal closing. Yes, thank you.
The bottom of page 853. Thank you.
Yep.
And then the same day, Oris write back. Thank you for your email regarding above. Contents noted and confirmed renewing as expiry. Await your premium closings in due course. So in other words, waiting the formal record of the reinsurance. And in relation to this, we have at 852 the slip in identical terms to the previous one, save for the date and the year of the policy. And again, with reference to our prior agreement, we confirm the following FAC reinsurance placement with you. And then at 851.
Sorry, is there a date on that? But that's
9th of June 2016.
But the request for renewal was the 22nd of June.
It was. But the insurance.
So the placement note preceded the request for extension.
Now, I think what's happened is that they've retrospectively added the date, so it is before the date of the reinsurance contract, because the renewal takes effect from the 10th of June. And if it wasn't dated in this way, you would have a situation where there was a gap in cover.
Yes. Okay. Thank you.
And then, as I said, 851, we have the credit note, which is as the last that we looked at.
Yep.
Now, there are no other documents relating to the reinsurance for the 2016 other than these. Moving on to 2017, this is at 859. You'll see an email at the bottom of 859, 11th of June 2017. Reference to your 100% participation in the above fleet account. Pleased to confirm having received a firm order to renew the above caption policy for a further 1 year on expiring terms and conditions. Again, our closings will follow shortly.
So what page was that again, Mr. Craig? I'm sorry, I missed it.
859. 859, right at the bottom of the page.
Thank you.
And then onto 860. Our closings will follow shortly. Meanwhile, kindly confirm the above noted and agreed for your share to enable us to proceed further. And then on the 11th of June, by return, top of 859, you will see we're pleased to confirm the renewal of our 100% share of the above mentioned risk for a further year. With effect from the 10th of June, await your premium closing. And then at 864, you see the slip for 2017. This is not backdated, dated 29th of June 2017. But again, it's in the same terms as the previous slips that we looked at. Again, with reference to our prior agreement, etc., and it contains the same words, warranted all terms, etc. And then at you'll see, in fact, at 865, this document appears to have been sent on the 13th of July. Please find attached closing along with the relevant credit note. Originals shall follow in due course. So in other words, not only is this document being sent by email, but the original slips are being sent direct to Auris. And then finally, we are into 2018. This is which is the relevant year, 867. First of all, we have on the 2nd of May, Abnick writing to Auris, reference your 100% participation of the above fleet account. Pending renewal terms to be agreed, please provisionally confirm your agreement to maintain your existing share for a further period of 12 months on expiring terms and conditions, awaiting your confirmation. At 869, that confirmation of provisional agreement is given. So that's at the bottom of the page on the 6th of May. Pleased to confirm our provisional agreement to renew. 868, at the bottom of the page, on the 7th of June, you will see that Abnick send to Auris an updated schedule. Essentially, the fleet is slightly smaller than it had been previously, and the overall value of the fleet has decreased. We await your reconfirmation of 100% share to enable us to proceed further. And then that is given on the 7th of June. Pleased to confirm the renewal of our 100% share of the above mentioned risk for a further year with effect from the 10th of June. Await your premium closing within 10 days period, bearing in mind our system will generate an automatic debit note after the expiry. And then at 925, you should have the closing. 28th of June 2018, and you will see here that the value of the fleet has come down. So the premium is lower than it was, but otherwise this is in the same terms as all the previous slips that were sent. As before, at 923, you will see the credit note for the premium. And in addition, by virtue of the changes in the tax regime in the UAE, there is now a tax invoice at 924, which was issued by Abnick to Auris for its commission. So there are no other documents relating to the 2018 reinsurance except for these. So our position is simply stated, the slip contains and evidences the reinsurance contract. This is clear from the documents we've just looked at, and it is also clear, we would suggest, from Auris's own witnesses. There was, in fact, no dispute from Auris's own witness that the slips contained the terms of the reinsurance contracts agreed annually. If I may, just take you to the transcripts. First of all, at page 1842, on page 38 of the transcript, at the bottom of the page on the left-hand side, you see the question, I'm going to move forward to 2016. Could I ask you, please, and then we're talking about 2016, and then if I could ask you to flick ahead to page 39, and I'm asking about the email that was sent by Oris to Abnick. This is line 17. He writes back saying, contents noted and confirm renewing expiry. Await your premium closings in due course. Yes. So the expectation is that Abnick will provide a document to it confirming the premium, yes, and also the existence of the cover so that there is some formal record of the reinsurance contract cover that is in place. Correct. And then you look at page 423, etc. Same terms as the slip for the previous year. This is the document that you expected to receive from Abnick effectively to give written confirmation of the reinsurance cover. Correct. Yes. Yes. And then we talk about the file for 2016. And then at page 1843, we talk about 2017. This is page 41. 2017, we refer to the exchanges of email. And then at the bottom of page 42, you refer to that email which attached the closing. This is line 19. That document, the slip, is in the same terms as the two we've already looked at, save the period of cover has changed. And that document is what you needed effectively for your records to ensure that there was a formal record of what the insurance contract was, correct? Yes, you agree. Yes. And then in 2018, we're now discussing at page 42, and then we look at the bottom of page 44 on the same page 1843, going back to Mr. Taylor saying, wait your premium closing. And then at page 45, that was the placement slip that we see at page 498. That's a document dated 28th of June. Do you see that? Yes. And again, it's in the same terms as the previous one, save for the decrease in value of the fleet. Yes. Period of cover changed. Again, this document was essential for the purposes of confirming the existence of reinsurance cover for your records. Yes. Am I right to understand? I'm right to understand, aren't I, that if this document became something which you thought, no, that can't possibly be right, you would have contacted Abnick to say so? Yes. If there is any difference, we would. So obviously the question of whether or not the slips contain or evidence the reinsurance contract is a question which ultimately turns on documentary exchanges. As I think you've already indicated, the court is in as good a position as the court of first instance to determine that question. And so it's only necessary for us to show the decision was wrong. In any event, in my submission, the decision that the terms of the slips were not terms of the reinsurance contract is plainly wrong. The judge plainly failed to take into account the evidence which he'd heard and arrived at a conclusion which the evidence could not support, and the finding lies outside the bounds within which a reasonable disagreement is possible.
Sorry, what was the name of the witness whose evidence you just took us to? I didn't note that. Can you just remind me?
Mr. Hamama, I think is his name.
Hamama, yes. Okay, I've seen his name. Thank you.
He was the only witness called by Oris. Yes.
Yes.
And going back to the judgment, you probably have it well in mind, but at page 115 of the bundle, and this is paragraph 122, the judge said, argument depends upon the placement document forming part of the reinsurance contract. Oris denies that it does, and I agree. I consider that in each year the reinsurance contract was concluded by the confirmation of renewal of cover issued by Oris. Placement document was an attempt to incorporate additional terms, and by its express terms requested specific agreement, which was not forthcoming. Now, in my submission, that is obviously wrong because the slips contain the contracts. Oris itself requested the formal records of the reinsurance on an annual basis. It was it that asked for the formal closings. Abnick and Oris are long-established insurers and reinsurers, and both are regulated businesses. They would expect to have a documentary record of the contracts they concluded. If the slips don't do this, there is no formal documentary record. And in that regard, if there wasn't a formal documentary record in this way, what would Oris have shown its retrocessionaires? The next point is that at no point in time did Oris ever say that the slips did not record the terms of the reinsurance contract. It was renewed on expiring terms, and those expiring terms are those which are contained in the slips. Now, the judge also said that because Oris didn't return a signed and stamped version of the slips, it was not accepted or agreed by it. Now, there is no dispute that the documents were not stamped and signed by Oris, but there is no requirement for it to be signed. The existence of the contract was not conditional on signature. The slips, as they state on their face, confirm a prior agreement. There is no signature block on the slips, which provides it's only binding when signed, and the request is simply that it be signed and stamped as a token of acceptance. In other words, evidence of acceptance. And in my submission, you look at what happened next, i.e. subsequently, the conduct of the parties to determine whether or not this is agreed. Now, to the extent necessary, this is clear. The fact one can have regard to that subsequent conduct is clear from the decision in Great North East Railway Limited and Avon Insurance, which is at page 2427 of the bundle. And you will see in paragraph 1, the question in that case was whether there was cover for business interruption losses. And at paragraph 20, which is at page 2432, there was reference to where the insurance contract was to be found by reference to certain documents. And at 2435, paragraph 29, in this case, the judge was correct to find it very telling that when Mr. Eilert was asked by his colleagues to obtain the terms of the contract, he sent them the Fenchurch terms. If the question is whether a term was incorporated into a contract, the subsequent conduct of the parties may be very relevant to the inquiry whether such a term was or was not agreed. And Mr. Flo's submission to the contrary, a misapplication of the principle, subsequent conduct of the parties cannot be relied as an aid to construction. No such principle exists in relation to the question whether an alleged term of a contract was in fact agreed. Here, we have the slip being provided on an annual basis in identical terms, save for the policy year and also in relation in the last year to the value of the vessels insured, and no objection is raised. And this is a document that is, as I said, not just sent by email, but the originals are actually sent to Oris. And in my submission, when you look at that objectively, what are the existing terms when the policy is renewed? In my submission, those are the terms of the slip for the previous year. That is the only record of what has been agreed. And so in my submission, the slip and the terms of the slip are obviously the terms of the reinsurance contract. That's all I intend to say on that issue, unless there's anything further that you would like to ask me about.
Well, what do you say the consequence of the inclusion of the follow the settlement clause is in the reinsurance contract?
It means that that to the extent that there is a liability found by way of a settlement or a judgment or some compromise, that the reinsurer, Oris, is bound to indemnify ABNIC.
And you rely on the decision in the House of Lords, I think, in Lexington and Wausau, for the proposition that it includes a judgment, not just a settlement. Is that right?
Correct.
Yes, right. Thank you. I think that proposition is contentious, but you can come back to that in reply after we've heard from Mr. Potts.
Thank you. So that is ground of appeal 3, if you like. I'm now on to the declarations appeals.
Sorry, just forgive me, just
course.
before we leave that. If hypothetically the Sharjah court produced some perverse judgment which bore no resemblance to the terms of the insurance, or more pertinently, the reinsurance, is that it?
In my submission, it is.
Yes. Okay, well, that's, as the Chief Justice said a moment ago, we may have to come back to.
Yes.
As to the scope of it. Your essential argument is the judge was plainly wrong.
Yes.
In saying the slip wasn't part of it, and he lost sight, one might say, of the context.
Correct.
And the consequence of his decision. But then we might at some stage need to return to the sort of outer limits of the placement document in due course.
Yes, so the outer limits, as it were, of the follow the settlements.
Yeah.
Yes.
Yeah, I think the point Sir Peter makes arises under your ground 1 and Mr. Potts' ground 3. Because they're both concerned with the extent to which you need to establish that the risk, the subject of the claim, is covered by both the primary level insurer and by the reinsurance contract. And that's, again, I think that's clear from Lexington and Wausau. But anyway, we'll come to that.
Yes. Now, grounds of appeal 1 and 2 concern the question of whether the judge should have gone to the declaration as sought by ABNIC. Now, when the hearing closed in April last year, it was not known what was going to occur in Sharjah. The judgment was handed down in the Sharjah Court of First Instance after the trial, and in that decision, the Sharjah courts determined that the DFC courts had given a final and binding judgment, and therefore that was the end of the matter. If we look at the judgment, this is at page 115. You will see paragraph 125, the judge refers to the Sharjah court finding of res judicata, and then at paragraph 126, the declaration sought by ABNIC asked me to speculate that the decision of the Sharjah court constitutes a res judicata, may be set aside on appeal, and then Oris submits, etc. And then at paragraph 127, he refers to the principles, and then he says, in my judgment, there is no real or present dispute between the parties before the court. Both parties agree the judgment was correctly decided. What will be the point of declaring what is agreed? The court should not grant declarations merely because the rights facts have been established and one party asks for a declaration. So pausing there, the judge plainly thought that the rights, facts, or principles had been established. But then he says, thereafter, the matter is shrouded in speculation. Will the Sharjah Court of Appeal uphold or reverse the Court of First Instance? Will the Sharjah Court of Cassation uphold or reverse the Court of Appeal? Etc. Now, just pausing there, the Court of Appeal did reverse the Court of First Instance. So that happened after this judgment. And at paragraph 128, sorry, 129, they then obviously declined to make the declaration sought. Now, in my submission, the judge was obviously wrong to decide that there was no dispute. There is a dispute, first of all, as to whether, if ABNIC is liable to indemnify Horizon, it is entitled to an indemnity from Auris. And then secondly, there is a dispute between the parties as to whether the judgment of His Excellency Justice Robert French on the claim brought by ABNIC in the DIFC court is the final word on liability under the underlying policy. Now, in connection with the relevant principles, if I can...
Well, before you go to them, Mr. Craig,
yes.
There were also, of course, disputes about the policy more generally, and in particular, defences were raised in relation to late notification and misrepresentation and non-disclosure.
Yes.
Now, all of those defences were dismissed, but no orders were made in relation to them. Isn't that a bit odd? Wouldn't you have expected orders to be made declaring that those defences weren't available?
In the context of the reinsurance claim?
Yes.
Yes, absolutely. To the extent that there was, I mean,
but,
yes,
but your appeal doesn't appear to be concerned with that. What you're after is what you call the liability declaration.
Yes.
Is that right? So
yes.
You don't want us to determine whether there should have been declaratory relief in relation to those defences. All you're concerned about is the liability declaration. Have I got that right?
Well, that's our principal concern. But obviously, if you're not minded to grant a declaration in our favour in that regard, then we would want because the last thing we want is for there to be a reopening potentially of issues should we bring or have to bring a further claim against Auris in due course, because undoubtedly it would then run every point. So to the extent we are not entitled to the declaration in relation to the liability, we would want final determination and therefore relevant declarations made in connection with all the matters which have been found, including, for example, a finding that the slip contains the relevant terms of the contract.
All right. Well, you haven't provided us with a document setting out the relief that you would seek apart from the liability declaration, have you?
We haven't, no.
Well, I think it'd be a good idea if you did, if that's what you want.
Okay, I can do that.
Yeah. Well, it seems to have been that, as the point the Chief Justice made, these findings seem to have been overlooked in terms of relief. But again, for my part, I completely agree. We need some wordings from you. I'm not planning on us starting to draft our own declarations.
No,
neither you nor Mr. Potts might thank us.
No, absolutely.
I think ideally that if that document can be provided today, Mr. Craig, then Mr. Potts can respond to it tomorrow.
Yes.
Good.
No, we could do that. In terms of the relevant principles on declarations, in my submission, a very helpful summary is provided in the judgment of Mr. Justice David Richards, as he was in Pavlidis and Hatchisava, which is at page 2746 of the bundle. And in this case, as you can see at page 2747, paragraph 2, the question was whether or not a declaration should be made in relation to the claimant's right to light. And at page 2752, at paragraph 22, the judge makes some general points about the remedy of a declaration, refers to the fact that the jurisdiction is statutory. And then paragraph 23, circumstances in which the court will make a declaration have broadened since the decision in Guriet and Union of Post Office Workers. And then paragraph 24, the principal developments have concerned questions which are not directly relevant to the circumstances of this case, such as whether the court will determine issues which have become academic, as between the parties, or whether all persons which will be affected are also not parties to litigation. The reference to the decision of Lord Justice Akins in Rolls-Royce. And then you will see with the qualification to paragraph 2, the dispute could relate to legal rights which might come into existence in the future. Moore-Bick LJ agreed with the summary in Marbush Properties. And then you will see, it will be noted, there is nothing in these general statements requiring an actual or an imminent infringement of a legal right before a declaration will be made. The willingness of the court in appropriate cases to make declarations as regards rights which may arise in the future or which are academic as between the parties suggests that the court's jurisdiction is not so tightly constrained. And then at paragraph 39, sorry, at page 2756, you will see there's been an argument about whether or not there must be an actual or imminent infringement of a right. Mr. Wicks cannot make out a principle that before the court will grant a declaration, there must be shown to be either an actual infringement or the threat of an imminent infringement. It's entirely understandable that there should be this requirement for the very different remedy of an injunction. The Chancellor decision in CIP property does, however, clearly illustrate the court may refuse a declaration on the grounds of prematurity or because it would not serve a useful purposes. And then the fact the claimants need not show an imminent threat does not mean a declaration should be made. The issue is whether the circumstances are such as to make it appropriate for the court in the exercise of its discretion to grant a declaration. Is there a real dispute between the parties as to make it appropriate to grant a declaration? And then on the facts of that case, it was decided that it was an appropriate case. And here you'll see at paragraph 48, it would be just and it would serve a useful purpose. In my judgment, it would, precisely because it would bring resolution and finality to this issue. In view of the previous history, I do not consider it would be just to deny that resolution and finality to the claimant. Mr. Weeks submitted defence would not be bound to prevent them from reasserting their prior position. Without a declaration, the claimants will be left in a position of uncertainty, with the defendants reserving the right to reassert their prior position on 14 days' notice given at any time of their choosing. And we say that's precisely the position here. Oris has denied it has any liability, whatever the outcome, as regards the liability under the underlying policy. Now, the judge, in deciding not to grant a declaration, had no regard to the relevant discretionary factors. And we, in our submission, that is a good reason for this court to interfere. I don't know if it's necessary for me to take you to the decision of Al Rehab Real Estate on the exercise of discretion and circumstances in which it's appropriate for the Court of Appeal to intervene. Are you happy with that test?
No, we recently reviewed all that in Crystal, the context of Crystal.
Thank you.
But Mr. Craig, while I'm interrupting you, the fact that the judge may have given a wrong reason for refusing relief doesn't mean that you're entitled to it, does it? So, and if we go back to the question I want to ask, if you go back to Lexington and Wasser in the passage of decision of Lord Mance, to which you refer us, he made the point that the follow the settlement clause extends to judgments, but there are two conditions which must be satisfied before the reinsurer is bound by a settlement or a judgment, as the case may be. The first condition is that it must be demonstrated that the risk giving rise to the claim was a risk within the scope of the reinsurance policy. And the second condition that must be satisfied is that the primary level insurer has acted honestly and in effect acted in good faith with a view to minimising the exposure, minimising the amount of the claim. Now, the problem with that in a case where there hasn't yet been a settlement or a judgment, I think there are two problems. Firstly, until you know the basis of the settlement, or in this case the judgment, how can you ascertain whether the risk that is the subject of the judgment falls within the risk covered by the reinsurance? And the second problem is, let it be assumed that up until now, ABNIC has done everything it can to resist Horizon's claim. But the hypothesis upon which you seek the declaration is that at some future time, Horizon will gain a judgment against ABNIC. It's impossible for you to demonstrate now that you have acted honestly and done everything you could to resist that judgment, isn't it?
Well, if that is a potential concern, then the declaration can necessarily account for it.
But then we get to prematurity. We're jumping at shadows here. We're assuming a judgment that hasn't been made. We're assuming conduct in relation to the judgment. Aren't there too many ifs and buts so that it would be a wrong exercise of discretion to grant a declaration where so little is known?
Well, in my submission, so little is not actually known, in the sense that, first of all, in relation to our conduct, we have clearly acted in a prudent and bona fides manner.
Up until now. But somehow or other, your hypothesis is that somehow or other judgment's going to get entered. Now, what if that was because your client lost interest and didn't oppose the subsequent proceedings, or didn't take appropriate steps? I mean, I think how would you cater for that in a declaration? You'd say subject to. Yeah.
Can I come back to you on that point?
Yes.
I mean, it may be. I mean, I think this is possibly going into the territory that we discussed.
It is.
20 minutes or so ago.
And it's also within the territory of ground 3 of Mr. Potter's appeal.
Yeah. Yes.
In other words, you haven't endeavoured to demonstrate that the risk that eventuated and gave rise to the claim is a risk falling within the scope of the reinsurance policy. And according to the authorities upon which you rely, that is a condition of your entitlement to claim under the reinsurance policy. And it's separate from the question of whether the risk is covered by the primary level of insurance. Both things have to be satisfied, and the satisfaction of one doesn't establish the satisfaction of the other.
Yes.
So that's the problem I'm seeing with the liability declaration, but you can come back to it at any time that suits you.
Thank you.
When you do, could I just add, speaking for myself, I found Lord Collins at 59 to 60 in Wasser very helpful.
Thank you.
And he sets out very clearly at the beginning of 59 the limits on the liability of the reinsurer. And the way I would put it is, it may be the judge was wrong for the reasons he gave to decline a declaration, but you still need to make good these points if you're going to get one.
Yes.
Even assuming you're right on the incorporation of the placement document.
Yes.
Well, you must succeed on ground 3 to succeed on ground 1, mustn't you?
Yes.
Yeah.
And 2, 1 and 2.
Yes. So we need to establish there is a real present dispute, and then the discretionary factors the judge didn't take into account at all, but when exercised correctly, there would be a declaration made. Yes. So but I accept that we have to succeed on ground 3. We have to follow the settlements clause before we're into the question of the relevant declaratory relief in relation to liability.
Sorry, just I don't want to delay everyone, but as it seems to me, you can separate 1 and 2 quite profitably. One is, was there a dispute? Is there a real dispute? Which in one sense is quite straightforward. And then two is the question, assuming there was a dispute, and assuming you're right on ground three, is there a proper case for a declaration at this stage?
Yes.
If yes, well, we know you succeed subject to the terms. If no, you may also, with respect, want to think about what we do about it.
Yes. So sorry, if there's no room for a declaration on the liability.
Yes, imagine
Yes.
imagine at this stage, we hypothetically we drew back from acceding to the application for declaration. What do we do? And
Yes,
other
well,
than say no.
Yeah, well, I think in that situation, we're into the other declarations in relation to the matters which have been determined by the judge, and seeking declarations on the back of those.
That's the document you're going to be producing later today.
Yes. Yes.
Yeah. Thank you.
In terms of, I mean, in terms of the declaration itself and the relevant principles of the carrying out of the discretionary exercise, the first question is, does it serve a useful purpose? And in my submission, it plainly does in circumstances where Auris has fought the claim for a declaration, and indeed has disputed its liability tooth and nail. And the declarations settled the question of liability for all. And it means essentially that if a decision is reached which results in ABNIC having a liability under the insurance policy, it is entitled to recover from Auris. It had, we submit, no alternative means of resolving the issue raised, and had it been regarded as premature or unnecessary, the court would undoubtedly have imposed a stay on Auris's application, which it was made in August 2024. In terms of,
but the question of whether it was premature is really a question for us. We can't be bound by what the judge decided in 2024. Can we?
Well, in the sense,
you're seeking the liability declaration from us.
Yes.
And the question of prematurity really turns upon whether you can satisfy the requirements in respect for your, in other words, are all the requirements for your claim under the reinsurance policy satisfied only because judgment is entered against you? And the problem I'm having, as I say, is that until that judgment is entered, you can't answer that question. Firstly, because you don't know the basis upon which the judgment is being entered, and secondly, and therefore whether it's the risk is within the reinsurance policy, and secondly, you can't know now whether your client has done everything reasonably done to resist liability. And that would lead to the conclusion that the declaration is premature, or that you haven't made out the entitlement to the relief that you seek.
I'll come back to that if I may.
Yes, certainly.
In terms of balancing the injustices, there is an injustice we would suggest to ABNIC if there is no declaration. It's on risk for a $70 million claim. If the relevant contingency occurs, it will not be able immediately to enforce the legal right to be indemnified. And given Auris's position to date, it's clear it will contest liability to indemnify ABNIC, and that could have very serious implications, I would suggest, for the solvency of ABNIC. We've had to bring this claim and fought over 2.5 years because Auris denies it's liable in any circumstances.
If we come to exercise the discretion, Mr. Craig, and you're basically saying that, pointing at what we would, then what do we do about the fact that there are no extant proceedings advancing a claim by Horizon? Wouldn't that be a powerful factor telling against the grant of discretionary relief?
Well, that is, first of all, I would suggest a product of where we are now as compared to where we were a year ago.
But you're seeking a liability declaration from us.
Yes.
And we've got to decide whether to grant it on the evidence before us.
Yes. And in relation to that, we simply rely upon what has happened to date with Horizon, and it's prepared to take whatever steps it will, and its refusal or its failure to respond to that letter of the 4th of June, which I took you to say we're not going to take any further steps. And in circumstances where we are, in my submission, it is appropriate and would serve a useful purpose.
Mr. Craig, can I just ask, we've got this very convoluted, if I might say so, set of proceedings. Is there a reason why Auris wasn't joined by your client in the proceedings involving Horizon? That would seem, given this welter of possibly potentially inconsistent litigation that we're all grappling with, and given that discretionary considerations arise as to utility and so forth, was there a good reason why Auris wasn't joined in your case with Horizon?
In the Charge Courts?
Yeah, well, anywhere in the proceedings before Justice French.
Well, without, as it were, disclosing any privileged matters, I mean, in relation to the matters in the DIFC court, we took the position that we would just defend, or rather bring the claim proactively. It was our claim, and brought against Horizon in order to establish non-liability on our part. In connection with the Sharjah proceedings, I'm afraid I've not been involved in those proceedings and don't know the circumstances in which, for example, procedurally, a reinsurer might be brought into those proceedings. So I can't, I'm afraid, help you on that.
Thank you.
In relation to, I mean, I would suggest there's no injustice to Auris if the declarations are made, because it has no substantive defence to the claim, such having been rejected at trial. The declaration we seek simply states what are Auris's contractual obligations. There is no risk of Auris's liability to indemnify ABNIC exceeding or preempting ABNIC's loss. And ABNIC has argued, as you know, that is not liable to Horizon because the underlying policy has been avoided, and the loss was not proximately caused.
Yes.
By an eligible and covered war risk within the relevant policy period. So if there is ultimately determination ABNIC's liable to Horizon, and this will only be after those issues have been fully ventilated and considered. That is all I'm afraid I have to say at the moment on the declarations, but as I say, I may come back in due course.
Yes. When do you want to address what is essentially your contingent cross appeal in relation to the governing law of the contract?
I was going to do that now.
Yes, good.
To whatever your own views on that.
No, that's fine.
So
can I start with a question?
Of course.
This ground was only advanced contingently upon the grant of permission to appeal to Auris.
Yes.
And I could understand that because Auris was applying for permission to appeal against the matters upon which it lost, which included issues relating to late notice, misrepresentation and non-disclosure, all issues covered by the English Insurance Act. And so if you secured decision that UAE law applied, those defences either went away or had to be recast. But permission to appeal in respect of those matters was refused. So I'm struggling to see the advantage that you get out of this ground, because your case largely relies upon the English contractual law for the inclusion of the placement note in the reinsurance contract, and relies on principles of English law relating to the implication of terms by reason of trade, custom and usage. Now, if you upset that apple cart, you would then have to establish all that under UAE law, and I can't see where in your submissions you've done that, but it may be that I've missed them. But I just wonder, and in terms of Mr. Potts, that case, I don't see how UAE law puts him at any disadvantage. So, because the issue that he raises essentially is the issue relating to the implication of the term. And he says, well, there just wasn't enough evidence to sustain the term. But can you help me with that? Why are we discussing this?
Because there was no under UAE law, the term would be implied without any question, and there was no issue raised.
Sorry, which term? This is the implied
term about defence
for reimbursement.
Correct.
Yes.
Yes. So that term, as a matter of UAE law, would be, as night follows day, a term of the contract, and there was no dispute about that. There was no issue raised by Auris that there was or wouldn't be such an implied term under UAE law. It adopted purely. Sorry.
Where do I find that process of reasoning somewhere in the papers?
So its only defence in relation to the implied term is in connection with under English law. It didn't plead a case that such a term wouldn't be implied under UAE law. And
Mr. Potts' head movements suggest to me that might be contentious. But what I'm interested in is how do I, as a person not overly familiar with UAE law, how do I get to the proposition that if UAE law applies, the implied term follows, as you put it, as night follows day? What is the statutory provision that has that consequence?
So the pleaded case. I'll have to come back to the pleaded case,
yes.
but I think it's at page 21 in relation to paragraph 9A, where it's pleaded the English law effectively is of application, and there's no alternative case pleaded, and there certainly was none argued.
No, but that's not my question. My question is that if you want us to find the implied term under UAE law, you've got to tell us how we do that. And I can't find that anywhere in your skeleton. It may be somewhere in the papers, but we need to know what your case is and what the point of your argument for UAE law is. You've complained in your skeleton about Auris saying here are all these provisions of UAE law which give us put us in the same position, but I think you might be subject to the same criticism. You haven't told us how UAE law enhances your case if we decide that it applies. You want to come back to that after you've tried to persuade us that UAE law applies, that's fine.
Yes. I will come back on that point if I may, because there was
Yes,
we closed on that basis in relation
Yes.
to the right under UAE law and the
Yes,
implication
all
of the term.
All right, that's fine.
Um,
I mean, you've got quite a formidable task on this. It looks like provisionally an English law contract. The judge looks as if he was right on this one. You've got to displace that. You
Yes.
may have other points in the case where one's first reaction is there's considerable mileage in your appeal.
Yes.
This one, yes. Well, anyway, there's quite a steep gradient, some might say.
I think the gauntlet's been thrown down, Mr. Craig.
Well, the starting point is obviously it's the proper interpretation of the waterfall provision, and the first question is whether there was an agreement on choice of UAE federal law, and if we don't get through that, the question is, was the nature of the transaction, did it have the closest connection with the UAE? Now, in relation to that first point, was there an agreement on choice? There is no dispute the reinsurance contract contains an exclusive jurisdiction clause in favour of the courts of the UAE. And in our submission, that indicates a reasonable and commercial expectation of the parties that UAE law would apply. If I can, just refer to the decision, first of all, of Enker and Chubb in the Supreme Court of England and Wales. And
Page number?
the judgment starts at page 3109.
Thank you.
And then at page 3121, at paragraph 35, this is the judgment of the majority, Lords Hamblin and Leggett, with whom Lord Carr agreed. And I don't know whether it's best to whether you just want to read that to yourselves, or whether you'd like me to read it out.
I think we'll just read it to ourselves.
Thank you.
Is that my colleagues have it? Yes.
Yes.
Right.
Thank you.
Yes.
Thank you.
Yes, I've read that. Thank you.
Yes, and so the key point is, even if it's an implied choice of law, that doesn't mean that it's not effectively a choice made effectively expressly, or that there's an agreement in favour of a particular choice. And then if I could ask you please to then look at the Arnold on Marine Insurance at 3354 of the bundle.
So what was that page again?
3354.
Thank you.
And it is the summary of the position. It's stated in Arnold: implied choice of applicable law, a common law, even where a marine policy not expressly stated to be governed by English law, a choice of law may be implied. An implied choice of law may be derived from the terms an exclusive jurisdiction clause. And it's important to bear in mind in this context that the jurisdiction clause here provides that UAE is the relevant jurisdiction. And so any court in the UAE has jurisdiction, not just the DIFC. And if the claim had been brought in the onshore courts, there's no question but that UAE federal law would have been applied by virtue of that choice of jurisdiction. And so it wouldn't make sense for, just because we brought in the DFC courts, that there would therefore be a different law applied.
So why do you say that if if proceedings were in the onshore courts, the UAE law would automatically have been applied. Surely, wouldn't those courts have also had to decide what the governing law of the reinsurance contract was?
No, because they take the position that in the absence of an express choice of a different law, UAE law, federal law applies. That's their position.
Thank you. Is there some authority? Is there some authority for that proposition? Is there some text or case you can refer us to
I can probably identify some. I'll get that to you.
All right. All right. Your homework list is increasing.
It is. Yeah. And then the second point is the closest connection. What is the place? What are the facts and the persons? Where are they most closely connected to? And in my submission, that is the UAE. I can go back to the judgment at paragraph 114, which is at page 112. The judge says that the closest connection is to English law, but the test under Article 8.2d requires an assessment of the facts and persons concerned in the matter. So the incorporation of London market clauses does not of itself, in my submission, indicate an intention to import English law or an English law interpretation. And the judge himself recorded at paragraph 95, this is page 105, this is referring to my submission, as Mr. Craig pointed out, the underlying contract of insurance and reinsurance are different contracts dealing with different subject matters. General words incorporating the terms and conditions do not necessarily demonstrate agreement to precise terms. Words incorporating terms and conditions of policy into reinsurance contract are ineffective to incorporate choice of law clauses from a direct policy. Specifically, in the context of a contract of insurance, reference to institute clause in the certificate does not evince the party's intention to choose an English governing law clause for the contract of insurance as a whole. So in my submission, first of all, fact of institute clauses doesn't mean English law. The second error in my submission the judge fell into was he then compared the content of the two jurisdictions. And you'll see at paragraph 111, which is at page 112, and you'll see Oris's submission institute clauses developed over a long period of time and the product of decisions of the English court, inclusion intended to create certainty. Given the sometimes difficulty of the language, English law may provide a ready store of guidance upon their interpretation to courts and tribunals who may not be immediately familiar with this particular form of reinsurance, etc. And then he says, I'm reinforced in this view by the fact that ABNIC, while contending for the application of UAE law, has not pointed to any decision of the UAE courts on marine hull war risk reinsurance. I infer, had it been able to do so, it would have done so in support of a contention. There is a body of UAE jurisprudence rendering it unnecessary to have recourse to English law. So in other words, the judge focused on the comparative content of those two systems of laws. And in my submission, that was not appropriate. And one could see that from the decision of the Court of Appeal in this court in the industrial group, which is at page 3520. And one of the questions on this appeal was the waterfall provisions, and we can see at page 3534 essentially there was a question as to whether or not there was a tort of malicious prosecution, and you will see at paragraph 115 reliance been placed on the words any other law and the judge's reasoning. Sorry, it's by paragraph 116. The third route advocated by Mr. Hamid for the incorporation of torts in the DFC laws by way of the waterfall provisions found in Article 8.2, where he sets them out. And you'll see the laws of the jurisdiction as agreed between all the relevant persons concerned in the matter, or the D, the laws of any jurisdiction which appears to be the one most closely related to the facts of and the persons concerned in the matter. And at paragraph 119, criticism of the judge's approach on the footing that if DIFC law was the law most closely connected under Article 8.2d, but the torts were not incorporated in DIFC law, so no remedy existed, then the words failing which meant the court was to apply English law. In short, the focus of the submissions was on the substantive content of the torts, and the application of the words failing which hinge on the content of the law in question. It was, he submitted, a nonsense issues law which does not exist. Paragraph 120 made quite clear, in our judgment, Article 8 is concerned with the choice of law rules going to determine the applicable system of law rather than the content of that system of law. The wording of Article 8.1 is plainly expressed. The rights and liabilities to be determined according to the laws, etc. The content of the law in the jurisdiction chosen is neither here nor there. It is whatever laws are for the time being in force in the jurisdiction chosen. The jurisdiction chosen in accordance with Article 8.2 is unaffective regardless whether a particular remedy is available or not. The fact that there is a gap in the law in the jurisdiction chosen does not trigger a default selection of the next jurisdiction in line. The words failing which do not refer to whether a particular tort or remedy is part of the law in question. They refer instead to whether the specified choice of law rule is established. Thus, defaulting to English law only arises if there is no close connection or other connecting factors requiring the selection of another jurisdiction. So far as concerns Article 8.2d, the closest connection goes to the facts and the parties, not to the substantive content of the jurisdiction under consideration. So that's why we say the judge fell into error there. And then in my submission, if you consider the facts and persons concerned in the matter, in my submission, bound to find that the reinsurance contract is most closely connected to UAE and had no connection to England. Now, those facts are set out in my skeleton argument at paragraph 44, which is at page 266 of the bundle. And I, unless you would like me to, I don't see the need to, as it were, read those out. Hopefully you can take them as read. But in summary, in my submission, the facts and persons are very closely connected to the UAE and not to, in any way, to England. So those are my submissions on that point.
Yes. Well, I think that takes us to the end of your first burst, doesn't it?
It is, yes.
Yes, all right. So we'll turn now to Mr. Potts. Mr. Potts, over to you.
His Honour, I think His Excellency Justice Patrick Anthony Keane had a question.
I'm sorry. I'm sorry. I missed that. Sorry.
If I might, the connection though is a connection with the laws of a jurisdiction which has a close relation to the facts of and the persons concerned, but the relevant connection is it not, with the jurisdiction as a law system and not with a geographical location?
In my submission, no, it's concerned with a geographical location. It's the place where things, it's the place connected most closely with, and therefore that determines the law.
Thank you.
Mr. Potts, over to you.
Good morning to all members of the Court of Appeal. Just 2 points of housekeeping to start with, because the bundles, electronic bundles, I think were updated or corrected this morning, and I just want to explain what we at least have put into them. Buried at the very back of the authority section, there's a reference to an Australian High Court decision called Akai, and the actual version of the law report that worked its way into the bundle was a decision of the New South Wales Court of Appeal, which was then reversed by the majority of the High Court of Australia. I'm not sure we'll need to get into it particularly, but I just wanted to draw your attention to that. And there's also, for what it's worth, in the bundle, there was a photocopy included of the underlying hull policy. And your honours will recall that there's both a war policy and a hull policy. But the version in the bundle seemed to be missing the first page of the hull policy. So that has now been inserted, I think, at the very end of the bundle as well, electronically. So those are the 2 points of housekeeping.
Thank you.
Mr. Potts, forgive me. I am working off a PDF version of the bundle supplied to me, I think, yesterday, which will not be updated automatically. Can your team ensure that I get PDF copies of anything which, with the page numbers, of anything which you say has been inserted, but which wasn't in the bundle as of yesterday?
Yes, I think perhaps Mr. Craig's team might be the ones who are best placed to do that, because there's also been, I think, insertion of statements of costs. And so the statements of costs have also been added to the end of the bundle, for which there was only a placeholder.
Well, I know it to be a nuisance, but I won't have it otherwise.
Yes. Okay. Well, yes. Sure, that can be done. And I
And
apologise.
Mr. Potts, I'm in the same position as His Excellency. So if you could do the same thing for me, please.
Yes, of course. Won't make you feel any better, but I'm in the same position as well, in the sense that I was also working off a static PDF and playing catch up with the insertions. The
incentive to add anything, you see.
Yeah. Well, perhaps if I could jump on the same bandwagon too, because I'm working off the document I downloaded last week.
Yes. Well, hopefully that housekeeping is helpful to some extent, but I do apologise that it's going to create a bit of work. The first then document I just wanted to make sure you had seen, so you understand where things are in Sharjah, because it wasn't entirely clear to me whether you had picked up on this. And I invite you to look, please, at a document which should be towards the back of the documentary section of the bundle. So my learned friend showed you, I think, a letter that Clyde & Co had sent to the Horizon representatives, dated the 4th of June, and that was at page 1613 of the bundle, page 1613.
Yes.
And I just wanted to make sure you had this in mind, that the letter provided reference at the second paragraph to the judgment of the Sharjah Court of Appeal on the 22nd of April, pursuant to which the appeal was dismissed and the decision of the challenge was upheld. And the next paragraph, we further refer to the attached certificate, and then a long number is given, issued by the Sharjah Court, confirming that no appeal has been filed against the Court of Appeal judgment within the prescribed time limit, and the deadline for doing so has now lapsed. Now, that certificate you'll find at page 1612, and the only version that Clyde & Co have produced somewhat unhelpfully, is an Arabic version, not an English translation. But our understanding was that the deadline for any appeal expired on the 22nd of May. And so here we are on the 29th of June with a certificate of the court making clear that the time limit has expired and that no appeal has been filed on a timely basis. So without wanting to labour a point, it can properly be said, as I think your Honour's instinct was to ask Mr. Craig, that the appeal, so far as there is the supposed shadow of a theoretical contingent liability arising in charge of litigation, that was obviously not the position before the judge at first instance, and I can come on to explain all the legal arguments about that as well. But despite an application to adduce further evidence in light of the subsequent development at the Intermediate Court of Appeal level on the first occasion, the position is that the charge of litigation is dead and buried. And that is indisputable on the evidence before this court.
Well, do we know if there's a provision for applying for an extension of time within which to appeal in Sharjah?
We don't, but the plaintiff or the claimant in the case, my learned friend representing Abnick, who has to establish quite a lot of things actually, but he would have to establish evidentially that there was still a remote contingent liability. He has not put forward any evidence to suggest that there is any ability to revive the litigation. Now, we can go through the documents, the English translations of the judgments of the Court of Cassation and the Court of Appeal, but they simply state what is obvious as a matter of law, which is that the judgment of Mr. Justice Robert French, His Excellency Robert French, was a final and binding unappealed judgment that gives rise to a res judicata as between those parties, with the consequence that this court of appeal, having confirmed the DIFC court is the relevant jurisdiction for the dispute, the Sharjah courts have no legal option but to follow and apply the DIFC court judgment of Mr. Justice Robert French, both as a matter of jurisdiction and as a matter of substance.
Well, Mr. Craig says that, leaving aside Sharjah, they are concerned that they might be sued in Dubai or Liberia or somewhere else. What do you say to that?
Well, I mean, it's a short point, which actually is an inevitable consequence of Wasser and Lexington and similar English authorities. But in theory, an insurer could be sued anywhere in the world. I mean, they could be sued in Miami, Florida. That they could be sued in a jurisdiction which has jury trials that can award many multiples of punitive damages. But the core question when establishing whether or not there is liability under a reinsurance is to ask yourself, is there, as a matter of law, liability under the primary insurance applying the correct governing law? And in this case, just want to make clear, we have a final and binding judgment of a court of competent jurisdiction applying the correct governing law that concludes with the finality that there is no liability under the war policy or the hull policy because both have been avoided ab initio. So even if there were not a judgment establishing that with finality, there would be difficulties in looking to the theoretical possibility that the insurer could theoretically be sued in some foreign court applying a foreign system of law. But if the foreign court did not have competent jurisdiction and did not publish a final and binding judgment in accordance with the applicable governing law, it would be a perverse, irrational irrelevance. It would not fall within the cover of the insurance or the reinsurance. So this fanciful concern that something might come back to life like a zombie, sufficient to trigger a contingent liability warranting some form of declaration, it's simply wrong. It's wrong as a matter of law, and it's wrong as a matter of fact. Now, it's not dispositive, of course, what each party thinks of the contingent liability, if indeed it is a matter of law, and if indeed it's a matter of evidence establishing a matter of fact. But it is relevant in the court below, in my submission, that during my cross-examination of the claimant's witnesses, I established, and there's a reference in the transcript I can give you, that ABNIC itself has applied a 0 reserve to the Buhaira Horizon claim. It itself, in its published audited financial statements disclosed to the market, assigns 0 value to the risk.
Well, how do we use that? What's the relevance of that?
Well, it's relevant because what we are really here to deal with in my respectful submission is the question of liability for defence costs. That's the meat of the case, and that was the meat of the case in the court below. Because, as I say, at risk of repeating myself, the French judgment is final and binding so as to give rise to res judicata. The principle of res judicata applies across the UAE, whether you're applying UAE, Sharjah, Dubai, DIFC, or English law, res judicata applies. And that was clear both on the evidence before the judge in the court below, both by reference to submissions on the law and by reference to what had happened so far in Sharjah, because the Sharjah proceedings had been stayed pending the decision of Robert French. What then happened was, after everyone closed their submissions, the hearing was closed, my learned friend's team, without permission, put in evidence of the Court of First Instance decision, and the Court of First Instance confirmed what everyone already knew at trial, which was the Sharjah courts would follow and apply the French judgment. There was then this perverse decision of the Court of Appeal, which did no more than simply assume jurisdiction. It didn't conclude the French judgment was wrong. It just simply said we have to revisit this as a matter of jurisdiction. That was then appealed to the Court of Cassation. It then was remitted back to the First Instance Court. Then it went to the Court of Appeal. And at every stage of the appellate hierarchy in Sharjah, the position has been taken as a matter of law and as a matter of fact on the evidence before the court that the French judgment is the end of the matter. So now,
sorry, what's reserving? How does their reserving policy help us?
Well, I'm going to try and explain this. Can I offer it to you in this alternative way? In the authorities, if we look at the textbook on the declaratory judgment, Zamir and Wolf, I just want to try and explain the point by reference to this bit of the textbook. Can I ask you to look, please, in the bundle at page 3338? At 3338, you'll see, I think, the front page of the declaratory judgment textbook. And I just want to invite you to look at page 3339. And it's paragraph 4-141 that I just want to draw your attention to. The declaratory power in private law proceedings doesn't extend to all rights which could be described as future rights. A distinction has to be drawn between hypothetical and future rights. Rights which will only come into existence if a contingency occurs may be described as hypothetical. They are in effect nothing more than a bare expectation of a future right, and are therefore outside the ordinary private law declaratory power of the courts. The rights which are being considered here are those which, though not yet in existence, are treated by the courts as certain to come into effect, either on a certain date or on the occurrence of some specified event. These rights are subject to the declaratory jurisdiction of the courts. But obviously there are very few things which are certain to occur, and if the courts were to categorize a right as hypothetical merely because of a remote possibility that a certain event might happen, the scope for declarations of future rights would not be limited. In order, therefore, to treat a right as being future and not hypothetical, the courts only require, for the purpose of their declaratory powers, a real prospect that the event will occur. Now, I think, although my learned friend hasn't articulated it in his submission, his real complaint is that before the judge and also before this court, there remains a real prospect, he would say, that the event that he is anxious about, or his client is anxious about, will occur. Now, we didn't need to debate before the judge what level of prospects of success one needed to precisely attribute to this claim, because, as I keep saying, as a matter of law, the claim is at an end. As a matter of fact, there was no evidence to suggest that the Sharjah court would do anything differently. And also, as a matter of fact, the claimant itself didn't have any genuine belief in my respectful submission, of any contingent liability, as illustrated by its own audited financial statements, for which it assigned a zero value. Now, I'm not saying that that is dispositive, because I totally accept the issue is one of objective analysis. And so what they themselves say subjectively is not dispositive. But it should give you a degree of comfort that even the claimant itself is shadowboxing in a manner in which its own lawyers, accountants and auditors and board of directors do not think is particularly important.
That might be said to be a point of prejudice, but perhaps quite effective.
Well, and if it will help to look at the transcript of the cross-examination on this point, I have footnoted it in a...
Sorry, Mr. Potts, I'm a bit sceptical. I quite understand your point about the real prospect test. I understand your point about whether the proceedings are concluded as a matter of fact or law. I'm just not immediately attracted to their reserving policy as assisting our decision.
Let me test it this way, Mr. Potts. What if they had put in a reserve of $70 million for this claim in their accounts? Would you accept that that was evidence in support of the degree of risk of the claim eventuating?
I mean, obviously I wouldn't, but it's not actually, well, in a sense, the answer to the point. But can I just show you then that the line of the transcript that we rely on? So it's at page 1773. 1773. Page 1773 of the bundle. You'll hopefully find pages 45 to 48 of the cross-examination of the claimant's first witness, Mr. Shalab, I think it was. And it's the very bottom right, so page 48 of the transcript, the bottom right-hand corner of the page. I've already established that there's a zero reserve as of 2021 to date. Line 5 on page 48 on 1773, to be absolutely clear, nothing for the $70 million value of the ship, no. And that is not something which has changed because of the judgment of Robert French in September 2024. It's the position you've taken on advice from 2021, isn't it? Yes, that's correct. And then line 19, so way before the judgment, zero reserve for the ship. Yes, because of course at the time the claim was not admitted, that's why. Question, that reflects the fact, doesn't it? It reflects the basic fact that Buhaira considers there to be no risk of the beta claim ever being successful. Answer, yes. So that's over the page at 1774. Now, I mean, I wouldn't accept this as just purely prejudice, but the point I'm making, if I may just wrap up on it, the French judgment is, as a matter of law, as a matter of English law, the end of the matter. The war policy and the hull policy have both been avoided. And I'm not sure if your lordships have read every paragraph in the Sharjah decisions, but we certainly suggest that they might be read usefully in our pre-reading checklist. But those courts have completely vindicated the proposition, which was the one accepted by the judge in the court below, that the Sharjah courts would defer completely to the judgment of Mr. Justice French because of the res judicata principle. And where we are is, just as there was no evidence of any actual contingent liability, there was no real prospect of anything happening differently. That was the evidence before the judge below. It is undoubtedly the position before this court today. Now, that, in a sense, takes us into Wasser and Lexington. And I'm sure your lordships have all now read it a number of times. I know you've made reference to both Lord Mance and Lord Collins. Before looking at it, I just want to pick up two additional authorities, which certainly in my submission are relatively helpful and consistent with that. There's the judgment of Mr. Justice Cresswell in CGU, International Insurance and AstraZeneca, Not sure if your lordships have read that or looked at it recently, but it starts, I hope, at page 2519. And if I can just ask you to pick up the judgment starts at page 2493 of the bundle. And the analysis conclusions, I just want to extract some general principles that Mr. Justice Presswell summarized at page 2519. So if you pick it up at F, just under the heading some general principles, it's convenient at this point of the judgment set up the following general principles of law. 92, reinsurance is prima facie a contract of indemnity under which the reinsurer indemnifies the reinsured against the whole or against a specified amount or proportion of the risk which the reinsured has insured. 93, it's not correct to equate reinsurance with liability insurance. Liability insurance is a species of original insurance whereby an assured insures the risk of it becoming liable to others. A reinsurance contract is probably defined something different. By a contract of reinsurance, the reinsurer insures the reinsured against the original loss, the insurable interest of the reinsured being constituted by its policy given to the original assured. Now, just pausing there, whether we analyze this as my response to Malone and Friends' appeal or in support of my own appeals, if the underlying policy is void ab initio, there is no insurable interest on the part of the reinsured.
But the claim is brought. The claim for the liability declaration is brought on the hypothesis that there is a binding decision of a court to the effect that the insurance policy is not void ab initio.
I accept that the hypothetical. I mean, we'll look at the way it's pleaded, the actual claim for declaration in a moment. But the hypothetical scenario is a hypothetical future contingent scenario that a foreign court or another court reaches a, in my submission, perverse and wrong conclusion. But in that unlikely event, we would somehow still be liable to indemnify. That would be in the face, though, of a judgment that's final and binding of a court of competent jurisdiction that has avoided the very policy, the war policy, which we are said to reinsure. Now, Your Honour, if I may say so, did ask my own friend a number of very pertinent points, explaining all the ifs and buts. But I'll come on to try and deal with this to assist if it helps. But you're quite right. On the authorities, one has to establish liability within the scope of the underlying cover, as well as liability within the scope of the reinsurance. As matters currently stand, we're not only thinking about some prospective future risk, we already have the benefit of a final and binding judgment that eliminates the risk. So, taking myself slightly out of order, but even if you ask yourself about the follow settlements provision, there's never been a settlement. There won't be anything to settle because we have a judgment, and the judgment inures to the benefit of both the insurer and the reinsurer, avoiding the policy. If there's going to be any settlement or judgment to follow, it's the French judgment which avoids the policy. You don't preserve the potential insurable interest in circumstances where, as a insurer claimant, you've secured your own declaration of non-liability from the court of competent jurisdiction in a final and binding judgment. So if we just go back to CGU International, just if I may finish off this citation, over the page at 2520, reinsurance is the insurance of an insurable interest in the subject matter of an original insurance. The principles of subrogation apply. So just pausing there, we wouldn't be subrogated to anything in circumstances where there's an avoidance of the policy. 94, contract of reinsurance is not an insurance of the primary insurer's potential liability. It is an independent contract between reinsured and reinsurer in which the subject matter of the insurance is the same as that of the primary insurance, being the risk insured. The difference lies in the nature of the insurable interest, which in the case of the reinsured arises from his liability under the original policy. Then we can look at Charter Re and Fagan if we have to. The point is, we're not there sitting in the background as a potential reinsurance of any contingent or potential liability, no matter how fanciful or perverse. We are there to reinsure the ship, assuming that the policy is valid and binding, but here it's not. Now, paragraph 95 on page 2520, a reinsurer is not liable to pay the reinsured until the amount of the reinsured's liability has been ascertained by judgment, award, or settlement. Now, as I keep saying, in this case, not only are we not in the territory of waiting for some judgment because everything's gone to sleep, it's at the end in Sharjah. We're not waiting for ascertainment by settlement because there's no settlement. What we have is a judgment that's ascertained that there is not liability. 96, the fact the reinsured has paid under the policy reinsured doesn't enable the reinsured to substantiate his claims against the reinsurer. Subject to any provision to the contrary in the reinsurance policy, the reinsured, in order to recover from the reinsurer, must prove the loss in the same manner as the original insured must have proved it against the reinsured, and the reinsurer can raise all defences which were open to the reinsured against the original assured. 97, where a reinsured seeks to recover under policy or reinsurance, the reinsurer cannot be held liable unless the falls within the cover of the policy reinsured and within the cover created by the reinsurance. And that's the point Your Honours have already made by reference to Lord Mustle and Hill and Mercantile. The effect of a clause binding reinsurers to follow settlements of the reinsured is that reinsurer agrees to indemnify the reinsured in the event the reinsured settles any claim by their insured, i.e. when the reinsured disposes or binds itself to dispose of a claim, whether by reason of admission or compromise, provided one, that the claim as so recognised falls within the risks covered by the policy of reinsurance as a matter of law, and two, that in settling the claim, the reinsured has acted honestly and has taken all proper and businesslike steps in reaching the settlement. Now, Your Honour, Chief Justice, quite rightly explained to my learned friend that there's complete prematurity here because we would not be possibly in a position of speculating whether or not the reinsured had, between now and some future event, acted honestly and taken all proper and businesslike steps. That's one difficulty. But the anterior difficulty is the claim doesn't just not fall within the policy of reinsurance as a matter of law. It's been positively held by Justice French to fall outside the policy of insurance and reinsurance because it's void the war policy. And for what it's worth, Mr. Justice French made no findings whatsoever to the effect that the underlying vessel was allegedly lost by virtue of a war peril. Mr. Justice Black has not made any finding whatsoever that the relevant ship was lost because of a war peril. We have no idea what a Sharjah court, if the case was ever resurrected, might conclude, but there's no reason to suppose on the evidence that was adduced at trial that a Sharjah court might conclude that the ship was lost by a war peril. Now, not only that, actually, the law presupposes there is a presumption as a matter of law that a vessel lost at sea is not lost by a war peril. The presumption is it will be either an uninsured risk or an ordinary marine peril. That would have to be displaced, that presumption, by evidence, of which there's none.
So you would say a declaration would suffer, a liability declaration would suffer or face the difficulty of one, prematurity, two, speculation, and three, not to put too fine a point on it, a complete absence of evidence that there is a peril within the reinsurance cover.
Precisely. And if I can just try and clarify the point I'm making in my skeleton of this, by reference to the judge's own judgment. The question of whether there's a real or present dispute has to be assessed by reference to the question of whether or not there's a real or present dispute about the existence or over the existence and extent of a legal right. And here, there wasn't any dispute over the existence or extent of a legal right, because the parties were agreed that as a matter of law and as a matter of fact, there was simply no cover under the underlying war policy, it had been avoided, or under the reinsurance. That was common ground. So if we go to the passages of the judgment where the judge is dealing with this point, I ask you to look now in the bundle, pick it up at paragraph 120, starting at page 114. Now, we have a respondent's notice before the Court of Appeal because, without wanting to criticize the judge was not writing an exam script. He was coming to the right conclusion, but not with the totality of reasoning that was properly available to him on the material before him at trial. But the starting point is the judge notes at paragraph 120 under the heading contingent liability, he refers to the follows settlements argument. He then concludes, as a matter of fact, and I'll come on to explain why he was right in this respect, that the placement document didn't form part of the reinsurance contract. He then goes on to explain that it simply would not know, this is paragraph 123 at page 115, that when the hearing closed, i.e. when all our closing submissions had gone in, all the evidence had closed, it wasn't known what would occur in Sharjah. He then says at paragraph 124, I've now been supplied with a copy of the judgment of the 19th of June. The case was heard on the 28th of May, judgment was delivered on the 19th of June. Paragraph 125, and this was evidence actually which was put in by the claimant after the hearing. In a reasoned judgment invoking the principle of res judicata, the Sharjah court held the DIFC courts had given a final and binding judgment that it was they who were the court of the jurisdiction. The avoidance of underlying insurance policies was now final and binding. I recognize the decision may be appealed to the Sharjah Court of Appeal, the Court of Cassation. It seems to me the declaration sought by Abnick asked me to speculate the decision of the Sharjah Court of First Instance, the judgment of Justice French, constitutes a res judicata, may be set aside in appeal. Aris submits that 1, this court can only proceed on the basis the Sharjah courts will continue to recognize the res judicata. And 2, Abnick is precluded from seeking to advance a collateral attack in these proceedings against the final and binding judgment of the DIFC court of the 26th of September. Now, paragraph 127, I have been directed to my decision in Charles Russell's speech leads in Grand Valley General Trading, in which I followed the practice in Rolls-Royce Unite the Union as the principles affecting the grant of declaratory relief. Now, just pausing there, the judge himself had given the leading local judgment in the DIFC on the relevant discretionary considerations as the declaratory relief. So it is an ambitious submission that he wasn't aware of the relevant factors. He went on to summarize, though, that the practice and the principles affecting the grant of declaratory relief include 1, the power of the court to grant declaratory relief is discretionary, and 2, there must in general be a real and present dispute between the parties before the court as to the existence or extent of a legal right between them. In my judgment, there is no real or present dispute between the parties before the court. Both parties agree the judgment of 26th September was correctly decided. So what he's actually saying there, he's saying that there's no dispute as to the existence or extent of a legal right, because there is no legal right to reinsurance on a marine war risks reinsurance contract if there's no actual legal liability under the war policy, in circumstances where the war policy has been avoided and there is no insurable interest. So what would be the point of declaring what is agreed? Now, as to the next bit of the paragraph, the future speculative matters, all of that material was quite right on the evidence before the court, because as a matter of law, it would have been speculative to suggest the Sharjah courts would do anything different. As a matter of fact, there was no evidence that they were going to do anything different. And what we now know is he was completely right in that prediction that it was utterly speculative and did not satisfy the test of a real prospect of a liability emerging. And so in the exercise of his discretion, he declined to make the declaration sought on such a speculative basis. Now, before just going back to Wasser and Lexington, can I just show you then also Lord Hoffman's speech in Charter Re and Fagan, because we've cited that and it is also helpful on this point. Can I invite...
Potts, we've been going for 2 hours. Would this be a convenient time, or would you like to deal with Lord Hoffman first?
I'm in your lordship, in your worship, in your honour's hands, Your Excellency's hands.
That's right. Very confusing, isn't it? Well, let's deal with Lord Hoffman and then break after that, shall we?
Okay, it'll be very quick, I hope. Can I ask you to look, please, at Charter Re and Fagan? It should be at page 2300. Is the passage I wanted to draw your attention to.
Sorry, what page? I missed the page number.
Sorry, 2300.
Thank you.
Now, I'm not going to take you through the facts of the case, and what the issue in the case really turned on is what was the true meaning as a matter of construction of pay as paid, whether you had to have actually paid or not. But in the context of that debate, what Lord Hoffman said at page 2300, just above letter E, these conclusions are reinforced by the history of reinsurance clauses. Contracts of reinsurance were unlawful until 1864. Such a contract is not an insurance of the primary insurer's potential liability or disbursement. It's an independent contract between reinsured and reinsurer, in which the subject matter of the insurance is the same as that of the primary insurance. That is to say, the risk to the ship or goods, or whatever might be insured. The difference lies in the nature of the insurable interest, which in the case of the primary insurer arises from his liability under the original policy. And then you can just read the next paragraph to yourselves. So having looked at that, we can come back after the break to then look at Wasser and Lexington, please.
Thank you. Now, I was going to suggest 20 minutes. Is that convenient to everybody? 20 minutes? Yes?
Yes.
Yes. All right. Okay. We'll adjourn for 20 minutes then. So we'll resume at 20 past the hour, wherever you are. Right. Just leave the lines open and turn off cameras and microphones, and we'll be back in 20 minutes. I think we're all back. Mr. Potts.
Thank you. Can we now turn to Wasser and Lexington, please? And I know you've read this, but it repays a little bit of careful study of certain paragraphs. Can we start, please, with Lord Mance's speech, which starts, for relevant purposes, at page 2647 of the bundle. The core points to bear in mind is that in this case, the underlying insurance was found as a matter of US law to impose enormous liability on the insurer, which was hard to contemplate from an English law point of view that governing the reinsurance. So if we can just pick it up at paragraph 32 on page 2648, just below letter C, more fundamentally, even a perfectly proportional reinsurance is not an insurance against liability, still less against any liability which the reinsured may be held to incur under the insurance. And then although the Court of Appeal, including Lord Justice Sedley, had thought that maybe that was the commercial reality, just above E at the end of that paragraph, Lord Mance pointed out that Lord Justice Sedley's thoughts were not well founded. Then at paragraph 33, reinsurance is a settled business conducted worldwide by experts, often possessing considerable legal knowledge and expertise. Well-recognized analysis, which neither side gainsaid, is that a reinsurance such as the present is an independent contract under which the subject matter reinsured is the original subject matter. The insurable interest which entitles the insurer to reinsure in respect of that subject matter is the insurer's exposure under the original insurance. The principle of indemnity limits any recovery from reinsurers to the amount paid in respect of that insurable interest. And then the citation there is both to Charter Re and Fagan, as well as the Forsikring Saktil Giskabet National of Copenhagen case, Toomey and Eagle Star, but also notably Section 9 of the Marine Insurance Act, which we have cited and which I can come back to. There's then a discussion of the regulatory context of reinsurance under English law. If we go over the page, please, to page 2649, 34, the first proposition is not critical to the resolution of this appeal. Both sides, in fact, accepted its correctness before the House. A conclusion that what is insured is the insurer's own liability would not entitle the insurer to indemnity against whatever liability it might be found to have in any court in which it was sued, under whatever law was there applied. Insurance against liability may, like any other insurance, be subject to specific terms which have to be satisfied before any indemnity can be sought. So just pausing there, in a sense, the point Lord Mance is making is apt in this case. If you imagine the hypothesis that a different court in Sharjah came up with some perverse ruling that there was liability, the point he's making here is that even if you can talk about reinsurance as a reinsurance against the insured's liability, it doesn't mean that you can get an indemnity for whatever liability might be found to be established in whatever court you might be sued under whatever law is there applied. So 35, that leads to the second point. An insurer seeking indemnity under reinsurance must, in the absence of special terms, establish both its liability under the terms of the insurance, its entitlement to indemnity under the terms of the reinsurance. Then there's a discussion of the follow settlements clause. And you'll see that at D, as interpreted by the Court of Appeal Insurance Company of Africa and SCOR Reinsurance, the effect of these clauses to bind the reinsurer to follow settlements of the insurer, whether made by admission or compromise, or as in the SCOR case itself, following a judgment against the insurer. Court of Appeal identified two provisos. The first, the claim so recognised, falls within the risk covered by the policy of reinsurance. The second, the insurers acted honestly and took all proper and business-like steps. Now, just want to, I'm going to assume you've read the next passages or that you will in due course, but can I just jump forwards then to Lord Collins' speech. That starts at page 2658. And similar points being made by Lord Collins at paragraph 55 on 2658. At D, the starting point is normally reinsurance of that kind is back to back with the insurance. The reinsurer and the original insurer enter into a bargain that if the insurer is liable under the insurance contract, the reinsurance will be liable to pay the proportion which is agreed to reinsure. Over the page, at paragraph 58, the solution to the question on these appeals, the reasons why they should be allowed, seems to me to be found on these steps. One, in order to establish a liability against a reinsurer, the reinsured has to establish the loss is within the risk assumed under the insurance contract. The relevant risk has been assumed under the reinsurance contract. Whether the relevant risk has been assumed under the reinsurance contract is a question of construction of that contract. In principle, the relevant terms proportional facultative reinsurance, particularly those relating to the risk, should be construed so as to be consistent with the terms of the insurance contract on the basis the normal commercial intention is they should be back to back. If we then drop down to letter F, halfway between F and G, subparagraph 8 or point 8, it's common ground under English law an insurer or reinsurer would not be liable for losses occurring before and after the policy period. Although normally any loss within the coverage of insurance will be within the coverage of reinsurance, there is no rule of construction and no rule of law that a reinsurer must respond to every valid claim under the insurance, irrespective of the terms of the reinsurance. 10, the reinsurance contract cannot reasonably be construed to mean that it would respond to any liability which any court of competent jurisdiction of the United States would impose on Lexington, irrespective of the period of cover in the reinsurance contract. And similar points are then repeated at paragraphs 59 and 60, which I would commend to you. Then just moving towards the end of the judgment, can I ask you to pick it up at paragraph 112 on page 2673. So the bottom of 112, in light of the arguments being put, this point applies also to the wider way in which Lexington would support the decision of the Court of Appeal, namely that any loss within the coverage of the insurance is also within the loss of the reinsurance, and a loss is within the loss of the insurance if so held by a court of competent jurisdiction, or if it's the subject of a settlement which cannot be impugned. The case for Lexington is not assisted by those authorities which decide the reinsurer cannot go behind a determination of the reinsured's liability under the contract of insurance the original insured, whether it's by way of settlement under a follow settlements clause or by the decision of a court of competent jurisdiction. And then after citing insurance, Company of African, SCORE, and Commercial Union Insurance and NRG, Lord Collins said, the reason is that a reinsurer will only be bound to follow its reinsured settlement and indemnify the reinsured, provided that the claim is recognised by them, falls within the risks covered by the policy of reinsurance as a matter of law. This is because the reinsurer cannot be held liable unless the loss falls within the cover created by the reinsurance. There's then at paragraph 113 the reference to Lord Hoffman's speech in Charteris and Fagan that I've already taken you to. And at paragraph 116 over the page at 2675, I would accept it would almost invariably be the case that losses for which the insurer has indemnified the original insured would be within the reinsurance, even if the losses are payable under a foreign law or a foreign judicial decision, which takes a view different from English law of what losses are recoverable. That's in the context of the underlying policy being governed by a relevant foreign law. Now, just to finish Wasser and Lexington, there's also a helpful speech of Lord Phillips, which you'll find at page 2637 of the bundle. And Lord Phillips agreed, you'll see at page 2637, paragraph 1, he agreed with both Lord Mance and Lord Collins. Paragraph 2, essentially the result of this appeal is dictated by the agreed fact the reinsurance contract, the subject of the appeal, is governed by English law, by the well-established principle, not challenged in this case, that under English law, a contract of reinsurance in relation to property is a contract under which the reinsurers insure the property that's the subject of the primary insurance. It's not simply a contract under which reinsurers agree to indemnify the insurers in relation to any liability they may incur under the primary insurance. Paragraph 6 at page 2638, Lord Phillips said that he agreed with Lord Mance, for the reasons Lord Mance gave, that the full reinsurance clause and the follow the settlements clause in general did not and do not have the effect of bringing within the cover of a policy of reinsurance risks that on the true interpretation of the policy would not otherwise be covered by it. And then in paragraph 8, the vital issue is reduced to this. Did the parties to the reinsurance implicitly agree that whatever law might be applied to interpretation of the primary cover and whatever result this might produce would apply equally to the reinsurance? An affirmative answer to this question would effectively treat the contract of reinsurance as one to indemnify the primary insurer in respect of any liability sustained under the primary cover. There might, as Lord Justice Sedley considered, be much to be said for adopting this approach, and it's an approach that would be open to the market by appropriate contractual terms to follow, but those who were party to this reinsurance didn't do so. Now that's a whistle-stop tour through it, but I'm sure your honours have the points that I'm trying to make by reference to it. Now, with that, I just wanted to make sure you'd seen the position in Sharjah and I hadn't overlooked something or made an assumption. Can I just double check, if we put Wasser and Lexington one side, can I just ask you to look at the latest judgment of the Sharjah Court of Appeal in the English version and pick it up at page 1602 of the bundle, 1602. This is the English translation that's been provided to us by Clyde & Co. of the Sharjah Court of Appeal's judgment of the 22nd of April of this year. And at 1602, what they said, it seems, in English translation, if you look in the top left, the second paragraph, 1602, it's established in the jurisprudence of the Supreme Court, any matter presented to the Court of Cassation on which it expresses opinion deliberately and with full consideration acquires the authority of res judicata, and the Court of Remittal, when hearing the case, is precluded from infringing that authority. The parties are precluded from re-raising what has been determined by the cassation judgment or disputing it in any manner, since the court is fully bound by the conclusion reached in the cassation judgment on the legal issues determined. So then the next paragraph, whereas the judgment issued by the courts of the DIFC finally determined the dispute between the same parties, holding those courts had jurisdiction, that the two insurance policies relied upon the action were void, and the insurance company was not liable for any claims arising thereunder, that judgment became final, acquired the authority of res judicata in relation to a fundamental issue upon which the determination of the right claim depends, namely the validity of the two policies, the extent of obligation under them, thereby preventing that issue from being re-raised or reconsidered in accordance with the authority of judgments and the stability of legal positions. The final sentence of the next paragraph, the conclusion reached by the cassation judgment in this regard is decisive and binding on this court. Whereas it's established from the papers as found by the judgment in the first instance, the judgment issued by the courts of the DIFC concluded the two insurance policies are void. The effect of this is the absence of any legal basis for claiming the value of the insurance, since there can be no obligation without a valid basis. Consequently, the liability of the insurance company is negated and the action becomes without subject matter. Accordingly, since the base of the present action is the appellant's claim for the value of the same two insurance policies were declared void by the final judgment issued by the court of the DIFC, which has acquired the authority of res judicata, it is legally impermissible to relitigate the dispute concerning them. Therefore necessary to dismiss the appeal and uphold the judgment under appeal in respect of the correct result it reached, which accords with fact and law. I won't take you to the Court of Cassation judgment, but it makes the same points. But I mean, when you join the dots between the judgment of Mr. Justice French, the judgments of the courts of Sharjah and Wasser and Lexington, it is quite clear in my submission that there is simply no scope as a matter of law for any contingent liability to arise under the insurance policy as a matter of law or under the reinsurance contract as a matter of law.
Can I just ask, please, the judgment at 1602, is that the Sharjah Court of Appeal or Court of Cassation?
Sorry.
It's probably my fault, I should know it.
No, so that is the latest judgment of the Court of Appeal, which is the Intermediate Court of Appeal. But it follows. I mean, the number of times that this has gone up and down already is I suppose surprising. But the Court of Cassation judgment is at 605. 605.
As I understand it, all that did was remit the matter back to the judge at first instance. Is that right?
It's not quite as simple as that, because if I can invite you then to look at that, the English translation starts at 605. So just remember that the IDRC in Sharjah had rejected jurisdiction because the DIFC court had jurisdiction. The Sharjah court had then stayed any Sharjah claim because of the DIFC court having jurisdiction. Once Robert French gave his judgment, by some strange coincidence, just as our trial was about to start, the Sharjah case started again. But the court of first instance said, once again, it's raised judicata because of the DIFC court's judgment. There was then this perverse appeal to the Court of Appeal, where the Court of Appeal said on the first time, we're not going to determine anything in favour of the claimant, but we're not satisfied that this court doesn't have its own jurisdiction. So we're going to sort of go back to square one. But then Abenick appealed to that to the Court of Cassation, and the Court of Cassation came up with a judgment in January 2026, which is at 605. And it's unfortunate it wasn't put before your worship, Your Honour, when granting permission to appeal and permission to adduce fresh evidence, because it was available by the time you issued your permission to appeal ruling. But at page 605, the English translation, this is now of the Court of Cassation, 19th of January. Can I just invite you to look at the bottom of page 606? You'll see that the appellant challenged the judgment of the Court of Appeal by way of cassation. When it was presented to this court in chambers, it found it worthy of consideration, set a hearing for its review. Whereas the appellant contends the appeal judgment violated the law and erred in its application, in that it ruled to overturn the appeal judgment and to grant jurisdiction to the Sharjah courts to hear the case in contradiction to the judgment issued by the DIFC, which ruled the DIFC courts have jurisdiction to hear the dispute between the parties, and on the merits declared the two insurance policies subject of the present case null and void, and the appellant insurance company bears no liability thereunder. This judgment has become final and binding and has acquired the authority of res judicata this is the top of 607, and no court may contradict it, which renders the appeal judgment defective and necessary to overturning it. Now, the Court of Cassation said this ground is well founded, as it is established in jurisprudence that Article 3 of Law Number 12 of 2004. And so the judicial authority of the DIFC provides, and it goes on to explain the DIFC's source of jurisdiction. The third paragraph, the effect of these provisions, the DIFC courts constitute an independent judicial authority with exclusive jurisdiction over matters assigned by them by law. They alone have jurisdiction to hear and determine any claim which DIFC or its institutions or bodies as defined by law as a party, as well as any civil or commercial dispute where the parties agree to the jurisdiction of the DIFC courts. Then the penultimate paragraph on page 607, it's established that if a matter is fundamental, its establishment or non-establishment determines the existence or non-existence of the right claim to the action, then the ruling on such matter requires the force of res judicata between the same parties, prevents them from disputing it again, whether by way of claim or defence, in respect of any other right whose existence or non-existence depends on that previously adjudicated issue between the same litigants. In the present case, it's evident from the documents the DIFC courts in case number 98/2021 to invalidate insurance policies rule they have jurisdiction to hear the case based on the clause containing insurance policies concerning governing law and jurisdiction, which provides the contract should be governed by English law and so forth. Over the page 608, this indicates the parties agree to designate English law as the applicable law in the event of any dispute between them, to submit such dispute to the courts of the UAE, including the DIFC courts. Next paragraph, that judgment became final after dismissal of the appeal, and the DIFC court subsequently ruled to declare the two insurance policies subject to the case null and void. The appellant bears no liability for any claim arising therefrom by a final judgment that has acquired the force of res judicata. Given the DIFC courts are an independent judicial authority and their final judgments have binding force and res judicata effect, they may not be contradicted. Since the base of the present action is the respondent's claim for the value of the same insurance policies subject to the previous case, the dispute concerning this policy has already been resolved between the same parties by the aforementioned final judgment issued by the DIFC courts, declaring them void, relieving the appellant of any liability thereunder. This prevents resubmission of the dispute concerning them, whether by way of claim or defence. Accordingly, since the appeal judgment has deviated from this view and ruled to overturn the appeal judgment and to grant jurisdiction to the Sharjah courts to hear the case, it has violated the law and erred in its application, which necessitates quashing it with remittal. So the Court of Cassation quashed the appeal judgment and remitted it for reconsideration by a differently constituted panel. And what then happens is it goes back to the Court of First Instance, who say, well, because the Court of Appeals judgment's been quashed, we have no jurisdiction, it's res judicata. That's on the 5th of March. Then Horizon try and appeal again. Court of Appeal, in the judgment I've just shown you, says, sorry, no, the Court of Cassation, which is the final Court of Appeal, has said it's res judicata. So there's no further appeal against that. Now, in a sense, as a matter of UAE law, when we were before the judge, it was easy enough to show the judge, and the judge accepted that on an application of English law and UAE law and DIFC law, DIFC court's judgment was res judicata. And that's what the Court of Cassation and the Court of Appeal have held unequivocally. So if you go back to Wasser and Lexington, it's hard to see how there is any spectre or contingent liability of some further perverse decision on the state of the evidence. But if there is any risk of a perverse decision, it wouldn't fall within the insurance or the reinsurance. It would be a liability which is not covered by the reinsurance. What I'd like to do next, if I may, is then come back to what are the terms of the reinsurance. And in a sense, that overlaps with points I want to make about the implied term that the judge found on the issue of defence costs. But it also relates to Mr. Craig's submissions about whether or not the placement documents were correctly found by the judge or not to form part of the reinsurance. So there's a little bit of ground to cover here, but the starting point, at risk of sounding like a chancery pedant, is actually in the pleadings. So can I just invite you to look, please, at the amended particulars of claim, which you'll find in the bundle, starting at page 7 of the bundle. Page 7, you'll find the amended particulars of claim. Now, these are amended because actually the judge had not been impressed with the way in which the arguments of UAE law were originally framed, and so bits have been struck out and had to be amended. But can I invite you to look, please, at paragraph 4 and 5. There's a discussion of the underlying policy, so the war policy in distinction to the hull policy. At paragraph 6 on page 8, the claimant pleaded the reinsurance contract. And the pleading of the reinsurance contract starts saying, pursuant to a contract of reinsurance, evidenced by a cover note for the underwriting year 2015, the cover note, and a document titled Facultative Reinsurance Placement dated 28th of June 2018. The defendant participated on a facultative basis in the 100% reinsurance of the underlying policy. Now, we accept that the cover note evidences the reinsurance contract for 2018, but we denied that the placement document constituted part of the reinsurance contract. So I'll come back to that. What was then pleaded was express terms of the reinsurance contract as follows. And by reference to the cover note, the claimant relied on these clauses: interest, trading area, cover, jurisdiction. Now I'll come back to the cover because that cross-refers to these clauses. But you'll note from the trading area, the trading area is worldwide, subject to London market, war risk trading warranties and exclusions. And then the only clause relied on as being supposedly a clause of the contract derived from the placement document is this clause which reads, and we've seen it, but we'll come back to it, warranted all terms and conditions as per original policy, and facultative reinsurers to follow all decisions agreed between the insuring company and insured in regard to all terms, conditions, exceptions, limitations, warranties, return, additional premium. The facultative reinsurers shall also follow in every respect all settlements agreed between the ceding company and the insured. Now, we don't accept that this is part of the reinsurance contract, but I need to make clear that even if it is, the short answer is, so what? It actually doesn't help the claimant, because if all terms and conditions have been warranted as per the original policy, and if the original policy is void, then it follows as night follows day that the reinsurance is void. If, in fact, there's a judgment by a court of competent jurisdiction that's final and binding that avoids the underlying policy, it follows that the facultative reinsurance take the benefit of that because it voids the reinsurance contract. Then we have paragraph 8. The pleading refers to the Institute Time Clauses hulls, CL 280. The relevant part, which are incorporated into the War and Strike clauses, CL 281, by clause 2 of CL 281, and which are in turn incorporated into the reinsurance contract. So the claimant's pleaded position is that the time clauses and the War and Strike clauses, hull time, are incorporated into the reinsurance contract. But the reliance was made on the sue and labour provision by way of an express term and the disbursements warranty provision by way of an express term. Now, at trial, without forewarning, my learned friend abandoned any reliance on an express term in his opening submissions. So that's the pleading. Now, as it happened, these documents were exhibited to the particulars of claim, and you can see that if you look at the footnotes at page 9, you'll see the reference to E1 for 15 to 20. Now in the appeal bundle, the exhibit hasn't been replicated in its precise form, but I'll have to take you to the documents that show what those documents are. So with that in mind, can I just ask you to look initially, please, at the reinsurance cover note, which we do know is part of the reinsurance contract on the claimant's case. So,
sorry, can you just help me? What was the point of going to the pleadings?
Well, because so I wanted to show you what the claimant's own case is as to what is the reinsurance contract. And at the moment, the only difference between us is on the placement document.
Yeah.
We said, but what's important, if I may say so, is to now look at the documents the claimant itself acknowledges is part of the reinsurance contract.
The only reason I ask is I didn't understand there to be any issue on this, subject to the placement clause or placement document?
Well, I'll
I
come
mean,
on to explain.
they say it's part of it. You say it isn't.
Yes, but in order to understand that, I also need to show you the documents that are part of it to put it into context to explain why that can't be part of it.
Okay.
If you bear with me for a moment, I'll try and develop the point. And if it's
Yes, there are gradients in this case which apply to both parties.
if it's not assisting, then by all means, please do stop me. But can I take you to page 848, please? 848, the cover note. And this is common ground that this is part of the reinsurance contract for every year from 2015 through to 2018. It's renewed annually. Now, the cover note, you'll see that it identifies the name of the underlying insured, the interests, what are the interests being reinsured, and we can see that it's hull war risks, hull war protection indemnity, and crew war protection indemnity. And these are being reinsured up to stated values. So we look at the sum insured, and the sum insured sets out the values, both in the aggregate and in terms of the sublimits for the different covers, as per the schedule attached. And there's obviously an unfortunate typo in the word schedule. We have the period of insurance, 12 months from 10th of June 2015. Then we have the trading area, worldwide, subject to London market, war risk trading warranties, and current exclusions. So the reinsurance cover note is subject to London market war risk trading warranties. The cover, now we see that the cover is subject to Institute War and Strikes clauses, including war P&I as per Institute Protection Indemnity War and Strikes clauses, that's CL 345, with clauses amended as follows. Then you'll see piracy, violent theft and barratry as per JW, so Joint War Risk Committee 2005-03, subject to compliance with BMP 2010 and piracy warranty hull. Over the page at 849, subject to current war exclusion, automatic termination, just drop down a couple, Institute Cyber Attack Exclusion Clause, CL 380, London blocking and trapping clauses, phrase 12 months in clause 3 of the Institute War and Strikes clause and London blocking and trapping clause amended to 6 months. Policy also to cover the liability of the assured to crew of the above vessels which arise from war and strikes and civil commotions as per Institute clause 281 for a limit of liability as per the schedule attached. Hull war P&I as per 345 with clause 1 amended to read underwriters agree to indemnify the assured in the manner to the extent provided in clause 1. Warranted application of JW, so another joint war risk clause, subject to 72 hours notice cancellation, subject to sanction limitation exclusion clause. The rate was as per the attached schedule, and the schedule, which I think you should find at 850, includes the sums insured for the fleet of vessels that were on the schedule, as well as the rate, the percentage, and the premium. So you could see that the schedule at 850 identifies what premium is payable. If you turn it at right angles, you'll see the premium of 70.25.4 in the final column. And then we know that the commission was 20% inclusive taxes. And there's a reference to 100% coverage and jurisdiction UAE. And the document is signed by both parties, by Aris, who's issued the cover note, and Al Buhaira, who's received it. And Al Buhaira has not just received it with a signature, they've stamped it with a reinsurance department stamp. Now, the clauses, which is common ground, are incorporated by reference, include the documents which you'll find at page 820, page 820. This is a copy of the Institute time clauses. There's another version of it with the same text, essentially, at page 826. Now, you'll see that at the top of each page, under the heading, there's a clause, this insurance is subject to English law and practice. Now, there's a dispute between Mr. Craig and myself as to whether that clause is part of the reinsurance. My submission is that it is. Now, most of the perils under the Institute time clauses are focused on non-war risk perils. And you can see that if you look at the bottom of 820 under clause 6, the perils. We get to clause 11, which is the sue and labour clause that was relied on by way of an express term. So that's at page 822. And my learned friend in his pleading had relied at page 824 on clause 22, the disbursements warranty. But if you look at the bottom of 824, you'll see that ordinarily this 280 document would exclude war risks and strike risks. So clauses 24 and 25 at the bottom of 824. We then turn to the war and strikes clauses, so 281. That's at page 832 of the bundle, page 832. And you'll see under the heading Institute War and Strikes Clauses, Hull's time, this insurance is subject to English law and practice. So once again, we submit that it's clear that the reinsurance contract is also subject to English law and practice. Now, the way that this works is you have the marine war risk perils listed at clause 1, at page 832. Then you have an incorporation provision whereby the war and strikes clauses incorporate some of the Institute time clauses that we've just been looking at, but not all of them. You then have exclusions at clause 5 at the bottom of page 832. And the insurance excludes loss, damage, liability, or expense arising from the outbreak of war involving certain countries, requisition for title or use or preemption, and then relevantly for our purposes, capture, seizure, arrest, restraint, detainment, confiscation, or expropriation by or under the order of the government of any public or local authority of the country in which the vessel is owned or registered. And then 5.1.5, operation of ordinary judicial process, failure to provide security, or to pay any final penalty or any financial cause. And then 5.5, halfway down 833, what's also excluded are any claim for expenses arising from delay, except such expenses as would be recoverable in principle in English law and practice under the York Antwerp Rules 1994. And then we have termination provisions. Now, I mentioned that the marine war risks cover also extended to crew protection and indemnity cover, and that is CL 345, which you'll find at page 817, And you can see the reference to CL 345 at 819, the documents being published by the Institute of London Underwriters. Institute Protection Indemnity War and Strikes Clauses Hull's time at 817. Again, this insurance is subject to English law and practice. And you'll see, although it's not that relevant for present purposes, the cover for P&I, crew P&I, but at 2 exclusions, there's also at 2.6 an exclusion of any claim arising from any financial cause. Now, one additional document that was incorporated, or wording, London market wording, is at page 834, and this is the violent theft, piracy, and barratry extension. And the violent theft, piracy, and barratry extension essentially extends the war risks, so that where the war and strikes insurance, the vessel is written on terms which include the Institute War and Strikes clauses, the said clauses are hereby amended as follows. 3 new clauses shall be inserted after clause 1.6 as follows: violent theft by persons from outside the vessel, piracy, barratry. This is a clause that's published by the Joint War Risks Committee in London. Now, with that in mind, what we in our respectful submission have is a reinsurance cover note that sets out quite clearly what documents are being incorporated by reference by a specialist marine war risks reinsurer to one of its 194 syndicated members. And in light of that, as I come on to show you, the judge was quite right to conclude that that, plus the renewal emails, are the totality of the reinsurance without regard to the placement document. To go into the email traffic, although I don't accept this is really appropriate or permissible for an appellate court, but to go into email traffic, can we just start it at page 835? At 835, you'll see that a representative of ABNIC emailed Mr. Hamama, the representative of Auris, on the 26th of May 2015, inviting him to ignore previous schedules and documents, but also making amendments to the cover note. So this policy also to cover the liability assured to crew of the above vessels, which arise from war and strikes, civil commotions, risks, etc., as per Institute clause for a limit of liability per capita, annual aggregate as per schedule attached. Now, before we get into the placement documents, can I show you the underlying policies? And the underlying war policy is probably what we need to look at first. The bear with me 1 second while I find the page for this. Sorry, just bear with me, please. Well, before we look at the war policy, I'm just going to take you to the version of the hull policy that you have in your papers, which, as I mentioned, unfortunately misses the first page, but it's not that important for present purposes. Can I ask you to look, please, at page 927 of the bundle. 927, you'll see that this is the second page of the hull policy. So not the one that we reinsure, but it was issued simultaneous with the war policy by ABNIC to Horizon. You'll see just by scanning down this document, lots of cross-references to London market wordings and institute clauses. And if you go over the page, please, to page 928, in addition to the fact that all the institute clauses have London or English law and practice clauses, the law and jurisdiction clause of the underlying hull policy provides the contract shall be governed by and construed in accordance with the English law. We now go to the war policy, the underlying war policy. You'll find us at page 919. Now, at page 919, this is the war policy issued by ABNIC to Horizon and its subsidiaries. You'll see at the bottom of page 919, this is for 12 months with effect 10th of June 2018 to 9th of June 2019, both days inclusive. And you can see that the same interests here are being insured as were reinsured, which is the hull war risks, the hull war P&I, the crew war P&I, up to the insured values. And you'll see the sum insured at the bottom of 919, the total fleet value, the per crew liability limit, the maximum liability per vessel, maximum liability of fleet, as per the schedule attached. And the schedule attached, you'll see, is at page 922. At page 920, you'll see the clauses and conditions following, first of all, the trading area. The trading area is subject to current London market war risk trading warranties. The cover is Institute War and Strikes clauses. The clauses conditions are now subject to similar documents, the ones we've already looked at, all these London Market and Institute clauses. At the very bottom of page 920, subject to no losses from 10th of June 2018 to 28th of June 2018. That's relevant because you'll see at page 921 that Buhaira was issuing the policy belatedly and retrospectively. You'll see it was signed on behalf of ABNIC on the 28th of June, although it was purporting to renew insurance from the 10th of June. And so there was meant to be a no loss condition to cover that 18-day period. But you'll also see at page 921 the contract being governed by and construed in accordance with English law. And for what it's worth, you'll see that there's an authorized signatory, Mr. Kadumi, who signed off with a stamp of ABNIC from the Marine and Aviation Department, Sharjah. So then go back to the placement documents. My learned friend in his submissions refers to it as a slip. He uses the phrase slip. Now that might have a word of no legal meaning, and it's just a word he casually uses. But my sense is that he's trying to convey to the court the impression that it's a scratch slip of the sort you might see in Lloyd's as constituting the reinsurance. It is not a slip in any conventional reinsurance sense of the word. I may have lost the court temporarily. Sir Peter's frozen on my screen. Can anybody hear me?
Yeah,
I can
I'm
hear.
very much here.
Okay, thank you.
Oh, yeah.
Because I can provide proof
No.
of life.
No, we
Thank
can see you moving now.
Sorry, so if we go to, so the point I'm making is that it's not a slip in the conventional reinsurance sense of the word. It's not a slip. What we have at page 925 is a document that's been produced by ABNIC that doesn't actually have any title or description on its face, but you'll see it's dated the 28th of June 2018. Now, this postdates by 18 days the inception of the renewal of the reinsurance for this year. And you'll see that the reference being made is with reference to our prior agreement, we confirm the following placement with you. The prior agreement is actually the relevant agreement, being the exchange of emails renewing. What this document then does is it identifies the premium that is due and the commission that is due. That's what actually it's doing. And you can see that because under the sums insured, which you need to know in order to calculate the rate, you end up with entries for rate, annual premium, your reinsurance share, your premium, reinsurance commission, net due payable to you. That is sent, as it happens on the evidence at trial, by email to the accounting department of ARIS. It was not sent to the reinsurance underwriter, but to the accountants. And it goes with the credit note, which you'll see at page 923. Credit note, page 923, and the tax invoice at page 924. Now, to try and make the point on the evidence that was before the judge as to how this went to the accounting department, we need to look at Mr. Hamama's evidence in re-examination. So can I ask you please to look at page 1842. Page 1842. can you see that page 37 of the transcript, line 12, am I correct to think it would hold the cover note and the credit note we've just looked at? Sorry, there's reference to a file. That would hold the cover note, the credit note, and the placement slip. No, sir. The premium closing goes to the account, technical account, not technical underwriting. But in terms of your file, I don't keep a copy. It goes to technical department, technical account, which they enter in the books and they follow the payment, not from the technical underwriting. We don't have this copy. If we need it, we go back to them under this reference. Can I then ask you to jump forwards to page 1853? Page 1853, page 84 of the transcript. At line 4 on page 84 of the transcript, at page 1853 of the bundle, we have, each department has its own duties. The technical department, which is underwriting department, transfers it to money goes to technical accounts. It's nothing to do with different, separate under the finance department. They check, they calculate, they ask us to pay. Okay, not us. So when the documents that are the premium closing documents, when they're received, which department is interested in looking at them? Technical accounts, yes. And why is that? Because they check the figures, they make the entries of the books, they follow payment. As you can see, this Ali was asking for, Mr. Ali is not an underwriter, it's his job to follow payment. So in order to check the books, it's not enough just to look at the credit note at page 410, is it? The attachment, on what basis he agrees it is 275 or not. And then he goes on to explain that there has to be some currency calculations done by the accounting department. If you then look at page 1855, so page 89 of the transcript, at line 18, and so Mr. Craig asked you whether you agree this confirm the terms of the reinsurance. Yes, but does this document confirm the terms of the reinsurance, or does it simply deal with the premium closing? No, premium closing is not any full terms and conditions, only classification of payment. We call it payment clauses. And if you look at the clause at the bottom, doesn't matter, doesn't mean anything. That phrase that starts warranted all terms and conditions and finishes for our records, was that clause anywhere in the prior agreement? No, it wasn't in. And to be clear, you never had anybody in the accounts team or in the underwriting team stamp this or sign it and send it back. Never. Would anybody in the accounts team have authority to agree to that? No. Would anyone in the underwriting team have authority to agree to that? No. As it happens, there was also evidence that after the loss was supposedly notified or alerted, ABNIC's representatives asked ARIS's representatives to countersign that document and send it back on a backdated basis, but that was refused. And that evidence was before the judge, which is why he alludes to it in his judgment. Now, with the greatest respect, that the trial judge was better placed by reference to the totality of the documents and the email exchanges, as well as the evidence of the witnesses. He was better placed than this appellate court is to get to the bottom of whether or not that placement document, on its true analysis, factually and legally, was part of the reinsurance contract. And his conclusion in his judgment was that it wasn't. Now, his conclusions on that issue are clearly set out in his judgment. So if I can just take you to those again. Sorry, Pete, just give me 1 second. The first point to note is he, of course, applied the question, he applied English law to the question of what documents constituted the contract. He So paragraph 122.
Page.
So it's page 115. Page 115 of the judgment. Paragraph 122. The argument that Mr. Craig had advanced by reference to the placement document and the following settlements clause, the argument depends upon the placement document forming part of the reinsurance contract. Aris denies that it does, and I agree. I consider that each year the reinsurance contract was concluded by the confirmation of renewal of cover issued by Aris. The placement document was an attempt to incorporate additional terms, and by its express terms requested specific agreement, which was not forthcoming.
Well, that's debatable, isn't it? I mean, there was a request to sign and return. Whether that was a condition that in order to accept, that was the only way the document could be accepted, or whether it was simply in the interests of good bookkeeping is debatable, isn't it?
I fully accept it's debatable, and it was debated in front of the judge. And the judge, quite properly in my submission, certainly within his evaluative entitlement as a judge, came to the conclusion that where you have a cover note that's been issued by a reinsurer that makes clear and careful reference to specific institute clauses and other clauses, which has, by the way, I'll come on to some other points about the values and the way in which premium is to be calculated. The mere fact that some 18 days later, a placement document is sent that addresses the amount of premium payable doesn't mean you incorporate by reference a follow the settlements clause, which is nowhere to be found in the primary cover note or any of the other clauses.
When you say 18 days later, it was 18 days after the retrospective inception of cover. How long after the renewal was it? Because the renewal was late, it had to be retrospective. So how long after the renewal was the placement note sent?
Can I ask you to look at page 868? Well, we can start it at page 870. Page 870, you'll see there's an email from Mr. Babu at Al Buhaira to Mr. Hamama. Reference your 100% participation. So this is the 2nd of May, so it's a month in advance. Pending renewal terms be agreed, please provisionally confirm your agreement to maintain your existing share for a further period of 12 months with effect from 10th of June on expiring terms and conditions, awaiting your confirmation. So it requires the operative step that's being taken in terms of offer and acceptance is that the reinsurer has to accept. That's when a contract comes into force. On the 6th of May, though, at page 869, Entisar Ateya emailed Mr. Babu on the 6th of May. Thank you for your email. We're pleased to confirm our provisional agreement to renew the above policy for a further year as from 10th of June 2018. Await your final confirmation to bind cover. Now, what that means in my respectful submission is that because they're only being asked to provisionally agree, they needed to wait for a final offer before the reinsurers could bind cover. So then we get the email of the 7th of June. Now, we never really got to the bottom of why everything was delayed, but a month later, but the day before the inception renewal, at the bottom of 868, thank you for your below email. Please find attached updated schedule for 2018-2019. Would appreciate your reconfirmation of your 100% share to enable us to proceed further. Then at 868, on the 7th of June, Ateya emails Babu, thank you for your below email, contents noted. We are pleased to confirm the renewal of our 100% share of the above mentioned risk for a further year with effect from 10th of June at expiry terms and conditions. Await your premium closing within 10-day period. Bear in mind that our system will generate an automatic debit note after the expiry of the said period. So what they're waiting for is not further terms and conditions of the cover that's been bound as of the 7th of June for the 8th of June. They're simply waiting for premium closing information. And that's for the accountants.
I think the question you were asked was how long after renewal was agreed. And I think the answer to that, looking at those emails, is 1 day.
Sorry, so between
this goes back to your 18-day point. And the Chief Justice asked you how long after renewal was agreed. And I think the emails you've just helpfully shown us suggest it might in fact be 1 day, unless I've misunderstood them.
I may have misunderstood something. The point I'm making is the placement document with the premium closing information was only sent on the 28th of June by email, and on the evidence it was sent to the accounts people. So that is,
and so that was what
that was 21 days.
That's the explanation for the no loss provision between the 10th and the 18th.
Between the 10th and the 28th.
Between yes, the 10th and the 28th, isn't it? So that, in other words, it was regarded that there wasn't a finalised policy until the placement note went out with the premium information. That's why they weren't going to cover any loss from the 10th.
Sorry, maybe I confused myself or the court, but that's condition, the no loss condition between the 10th and 28th, that was in the underlying policies issued by ABNIC.
Right.
So essentially, the reinsurance is confirmed on the 7th of June, so as to take effect on the 8th. It's renewed as per the historic cover note. Each year it'd be renewed on the expiring terms of the reinsurance cover note. And then we sit around waiting for 21 days to receive a placement document, which is sent to us for the purpose of calculating the premium amounts due, but is not a document that is part of the negotiation for the terms and conditions of the reinsurance, because that's already been fixed. It's already been agreed as at the 7th of June.
But there's no binding agreement until you resolve price, is there? Price is a fundamental term.
No, because it's already been calculated. We already know from the schedule that we've been sent. We already know what the insured value of the fleet is. We know what the insured value of the fleet is because we get sent the schedule of the vessels. We know what the premium rate is and what we get, and we know but we're just looking for a accounting document that essentially bills us for the commission and accounts to us for the premium. So the judge quite rightly formed the view that you don't. I mean, as it happens, it shouldn't be that surprising that in a war risks reinsurer, it's the underwriter who's got to either scratch his signature or apply the company seal before binding the reinsurer to terms. They've done that with the cover note, which you saw was stamped and countersigned. And they're being sent an accounting document where someone tries to slip in, like the Battle of the Forms, a clause, but knowing full well the clause will be meaningless unless it's agreed, returned, stamped, and signed. And it never is. Nobody in the accounting department who received that document had the authority to agree to it. And as it happens, both under the Marine Insurance Act in England, but even if one was to apply UAE law under the UAE relevant provisions, an insurance contract and a reinsurance contract has got to be in writing. You wouldn't expect it to be contained in a unilateral document from the reinsured with calculations of premium. Now, obviously, if time permitted me to take you through every line of evidence and every email exchange to explain to you why my submissions to the judge the way that they were, and that he accepted them as the trier of fact, then I would do that. But this is an appellate court, and the real question is: was the judge on this issue of fact? Was he plainly wrong? Well, he wasn't plainly wrong, because you can see from the chronology alone, the document post-dated the renewal by 3 weeks. as it happens, the court can take a measure of comfort from the fact that it's utterly academic. It's utterly academic because there's no settlement to follow. And if one incorporates that clause into the reinsurance contract, it also follows as night follows day that as the underlying insurance has been avoided, so too is the reinsurance, because it's on the precisely the same terms and conditions on my learner friend's theory.
Mr. Potts, may I just ask this? Am I right in thinking there was a similar document each year?
Yes. Each year they had to account for the premium, so they sent a similar premium closing document to the accounts team with the figure.
And your case would be the same for each year?
Precisely. There's a slight difference of timing each year, because I think when they start the process, the accountants are quicker to send the documents, so they follow a day or two later. But by the time we get to 2018, they're following 3 weeks later.
Thank you.
To try and illustrate why we find this point also a little bit confusing, can I just invite you to look at a letter that was sent during the course of the litigation by my learned friends instructing solicitors, which you'll find at page 1094. 1094. At page 1094, you'll find a letter from Clyde & Co. dated the 14th of March 2023. And can I ask you to look, please, at paragraph 4G on page 1095. What Clyde & Co. represented to Aris in this letter was, for present purposes, there is no settlement with the insured envisaged, and so the follow settlement clause does not as yet come into play. This is a point we raise for completeness, which we shall keep under review. There's never been a settlement. There never will be a settlement. It's completely irrelevant.
Well, except that settlements include judgments.
Yeah, the only judgment has been a judgment avoiding the policy.
Well, I think we're going around in circles a bit.
Well,
because again, the claim is based on the hypothesis that there will be a judgment. Now, we know you don't accept that, but that's the basis upon which it's brought.
I understand that, but as I say, that clause in our submission was not part of the policy, the reinsurance. I think you have my submissions on that. We do mention our skeleton. We illustrate the point by reference to at least one English judgment in which a judge with a similar problem concluded that clearly that was a subject to contract style clause because it contemplated that it would be signed and returned. And of course, it's open to a trial judge to conclude it was sent on a subject to contract basis. If somebody's expecting signature and stamping, and if after the event they're asking if it be signed and backdated, it can be well interpreted to mean that clause is not in unless it's been expressly agreed. Let me just try and organise my thoughts as to where that gets us. Can I just ask the court whether you need any further submission from me on the applicability of English law and the judge's findings in that respect?
Well, Mr. Potts, how you use your time is entirely a matter for you.
All right. Well, you've seen, I've shown you the provisions of the institute clauses that refer to English law and practice. You've seen the underlying policy documents that refer to English law being the applicable law. Now, of course, there's a whole lot of other relevant criteria that one could take into account if one was trying to work out which law had the closest connection with the relevant transaction. And the fact these are written in English, subject to English standard forms, is quite a relevant consideration. The judge approached matters on the basis that he did not accept that there was an agreement on objective analysis between the parties as to the governing law. And so he approached matters on the waterfall by looking for the closest connections. Now, in our respondent's notice, we respectfully suggest that he was in error not to conclude that there was, in fact, agreement on objective analysis. And the reason we say that is obviously because the Institute clauses contemplate, by their terms, the application of English law, and the underlying policies contemplate and specifically provide for the application of English law. Now, it may be a jury point to some extent, but in support of my learned friend's case in the DIFC court while establishing jurisdiction, he also made the submission that the reinsurance was governed by English law. And it was subsequently suggested that submission was made in error. But with the greatest respect, it's very hard to see how it could have been made in error in circumstances where that is the most obvious interpretation we suggest of the agreement.
Now, was
Sorry,
that
I've
in these
lost- I've lost
proceedings or was
track.
that in the... Sorry, you go.
And I was just going to say, I've lost track of it. In which court was this made?
Okay, let me back up a second. So
I mean, does it matter?
it's something that we relied on in the court below and that we rely on in support of our submissions. But does it matter? It's not the most important point. It's just that in establishing jurisdiction in the DIFC, my learned friend in his submissions to the DIFC before Mr. Justice Giles did make positive submissions to the court that the reinsurance, the marine war risk reinsurance with my client, was governed by English law. So it's an inconsistent submission that surfaced in this litigation that somehow the reinsurance was surprisingly governed by UAE law. Now, the reason that's, in a sense, a little bit more relevant is because some of the points the judge picked up on were points that had also been made by my learned friend in his own submissions to the DIFC court, to the effect that English law was the logical law to apply in circumstances where the policies themselves incorporated standard London marine market clauses, the Institute clauses, which were the product of a long line of analysis, the inclusion intended to create certainty as to the perils insured. Now, just to develop that point by reference to the case law rather than just my learned friend's submissions, can we look, please, at the Amin Rashid decision in Kuwait insurance? So for that, I'm going to ask you, please, to look at page 2092. You'll see the front page, the judgment of the House of Lords of Amin Rashid. It's actually at 2080. And it might be helpful if you were to read the head notes to yourselves before I get into the paragraphs of the judgment. But if you can read 2080, summary of the facts from C to G, and then the head note, please.
Yes. Well, I've read it. I don't know about my colleagues.
Thank
Yep.
you. So what you'll see from the head notes is that four members, Lord Diplock, Lord Roskill, Lord Brandon, and Lord Brightman, concluded that English law applied in this case as a matter of necessary implication. One of the judges, Lord Wilberforce, approached matters on the closest connection test basis. And in a sense, there's a high degree of overlap between the facts of our case and the facts of this case. So you can see that if you jump to page 2092 in the speech of Lord Diplock, just beneath letter C on page 2092, I can state briefly what Lord Atkin refers to as the relevant surrounding circumstances at the time the policy was issued, before I come to its actual terms. Since although the policy contains no express provision choosing English law as the proper law of the contract, nevertheless its provisions taken as a whole, in my opinion, by necessary implication, point ineluctably to the conclusion, intention of the parties of their mutual rights and obligations under it should be determined in accordance with English law of marine insurance. And then there's quite a long discussion about that, but can I ask you to then jump to, I commend to you pages 2093 and 2094, but can we look at the
I see on page 2092 his lordship refers to telex as a modern means of communication.
Yeah, it is. Yeah, I mean, it's obviously a case of its time, but the principles, in my definition, still stand up to scrutiny. Can I also look at page 2094, just beneath A? Turning to the terms of the policy itself, the adoption of the obsolete language of the Lloyd's SG policy, as scheduled in the Marine Insurance Act, makes it impossible to discover what are the legal incidents of the mutual rights and obligations accepted by the insurers and the assured as having been brought to existence by the contract, unless recourse is had not only to the rules for construction of the policy contained in the first schedule, but also to many of the substantive provisions of the Act, which is described as its long title as an Act to codify the law related to marine insurance. To give some examples, the policy is a valued policy. The legal consequence of this in various circumstances prescribed by sections 27, 32, 67, 68. The policy contained two typewritten insertions, warranted Lloyd's class to be maintained throughout the policy period, warranted trading in Arabian Gulf waters only. The legal consequence of the use of these expressions in a policy of insurance is laid down in sections 33 to 35. Then there's reference to the sue and labour clause. The legal effect of the sue and labour clause, including the policies laid down in section 78. These are but a few examples of the more esoteric provisions of the policy, of which the legal effect is undiscoverable, except by reference to the Marine Insurance Act. Just at F, except by reference to English statute into the judicial exegesis of the code it enacts, it's not possible to interpret the policy or determine what those mutual legal rights and obligations are. So applying, as one must in deciding the jurisdiction point, English rules of conflict of laws, the proper law of the contract embodied in the policy is English law. And Lord Wilberforce had a slightly different analysis, although he gets to the same result on the facts of this case. And you'll see his speech starts at page 2098. But he was in the minority in saying it's not a question of implying by necessary implication English law. We're looking for connecting factors. But if I invite you to look at page 2101, you'll see that he adopted the approach similar to the judge in our case, just above E. In my opinion, the classic process of weighing the factors must be followed with all the difficulties inherent in the process. They're well and clearly listed in the judgment of Sir John Donaldson. I agree with him. The majority of the ingredients said to connect the policy with English law are irrelevant or lacking in weight. These include payment of premiums in sterling, the use of minute London brokers. The significant factors remain the use of this form of policy expressed in English language, requiring interpretation according to English rules and practice, the nationality of the parties, defendants being incorporated carrying on business in Kuwait, plaintiffs being Liberian resident in Dubai, use of English sterling as money of account, Issue of the policy in Kuwait I regard as little weight. Provision in claims to be paid in Kuwait. This too is a minor consequence in view of the practice established at the time of contracting of settling claims in London. I think also for myself, it's not without importance the policy contains no choice of law clause. With the policy in a form so essentially English, the absence of such a factor leaves the form and language as pointed towards English law without what would one consider as a natural counterweight. I agree the omission of the Lombard Street or Royal Exchange or London clause is insignificant, but I regard the incorporation of the institute clauses with express reference to English law provisions as important. And he reached the conclusion at the top of 2102, English law is proper law of this particular contract. In summary, when you have a look at that case and the reasoning and take it to be the waterfall of options available to the DIFC court, in our submission, actually, the proper conclusion was that by necessary implication, the contract was governed by English law as a matter of agreement. So the judge was wrong not to make that finding, but he was right in the conclusion that English law in any event applied on the closest connection analysis. Now, the court has asked my learned friend, where does this get us and what's the point of all of this, given that his primary grounds of appeal assume the application of English law? In my submission, the likely reason is because of, in a sense, the most important part of the case being our appeal on the defence costs. And for two reasons. One, English law is settled at the highest level that there is no implied term for payment of defence costs in a reinsurance contract of this sort, subject to the theoretical possibility that a court might conclude that there's an implied term as a necessary consequence of universal market practice. In a case of a contract that expressly includes London market clauses and institute clauses that expressly state they are subject to English law and practice, and that is integral to the interpretation of the clauses, in my submission, what the judge at first instance should have done is acknowledge that the relevant market for analysing the possible application of an implied term was the London market. Because the entire reinsurance is premised on London market being the relevant market. My own friend, of course, persuaded the judge in the court below that London market practice was somehow irrelevant, but that what the judge thought was relevant was the question of what was the market practice in some undefined region of the UAE or the Middle East. Now, I fully accept that the judge had two expert witnesses put before him, like ships in the night, one addressing the position as a matter of London market practice, and the other one purporting to address the position as a matter of Middle Eastern market practice. What the judge didn't do in his judgment is analyse what was the relevant market.
Can I ask you, what? It's just a point in this issue that he says the judge says UAE and Middle East, or UAE or Middle East. But what is the Middle East if I'm looking at a market? I mean, is that the UAE, Kuwait, Bahrain, Oman, Qatar? What are we talking about?
Well, in a sense, we are as we are baffled, and now there's a procedural history here, which, in a sense, the court needs to understand.
Sorry, I don't want to take you out of your turn, so do it when deal with that, please, when it's convenient.
We submitted to the court below, and we respectfully suggest that the expert David Williams' evidence was consistent with this proposition, that what the court should be looking for is a relevant market for the reinsurance of marine war risks. Not insurance, not primary insurance, not underlying insurance, but reinsurance of marine war risks. Now, as it happens, ARIS, the Arab War Risks Insurance Syndicate, my client, is a specialist marine war risk reinsurer incorporated in the Kingdom of Bahrain, so not in the UAE. Now, it's a bit like a mutual. It has a syndicated structure whereby it offers that product to 194, I think even today, maybe 200 insurers across the Middle East and North Africa, including essentially all Arab-speaking jurisdictions. But the mere fact that we are one provider of marine war risks reinsurance does not a market make. And if you're going to look at our market, our monopoly, one might say, is in the Kingdom of Bahrain.
Why do you describe it as a monopoly?
Because we're the only one. We're the only one who provides specialist marine war risks reinsurance in Bahrain.
Is there evidence of that?
I'm not sure there was developed evidence of that, but Mr. Williams.
Then we got to stick to the evidence.
Well, the way I put it to the court is that the party seeking to establish the implied term had the burden of establishing that the implied term existed. And so what they had the burden of establishing on the evidence was that there was a relevant market for marine war risks reinsurance. Now, properly understood, Mr. Abdeen's evidence did nothing of the sort. He was not a marine war risks reinsurance underwriter. There was no evidence of anybody else operating in this market.
Why is the market so specific? Why is it marine war risks reinsurance? Why couldn't it just be reinsurance generally?
The answer to that essentially comes from the judgment of Christopher Clark in the Gossel case, but it may be that there's scope for a reasoned argument as to what should be the perimeters of the relevant market. But the marine reinsurance, whether it's war risks or non-war risks, is framed as property reinsurance by reference to stated values. Now, in this case, both the hull and the war policy and the reinsurance were subject to institute clauses, which were London market practice. Now, one could say it's the same analysis, whether it's marine non-war or marine war, but certainly marine reinsurance, we respectfully suggest, is the sector you're looking at, marine reinsurance. And the question then, what is the relevant market to assess the market practice in? And we can go through Mr. Abdeen's report or his cross-examination, but essentially you have one individual who's the CEO of a tackle provider, not a marine risks reinsurer, who expressed his personal opinion that subject to the terms of any particular contract, reinsurer is always paid. And in support of that, he didn't explain what were the parameters of the market he was considering, what were the outer edges of the UAE or the Middle East, and nor did he explain any reasoning as to why you could say there was a universal market practice if in fact it all turned on the relevant terms of any given policy. And he didn't provide a single policy to illustrate his opinion. He didn't offer a single textbook to illustrate or support his opinion. And he even went so far radically to suggest in his evidence that ARIS, being only a marine reinsurer, should pay 100% of the defence costs, regardless of the fact the underlying case involved the hull policy.
Mr. Potts, in the context of your argument about placement of about the significance of the placement note, you encouraged us to to leave the matter to the trial judge on the basis that he had a significant advantage over us. Now, why doesn't the same apply to this proposition?
Well, I mean, Your Honour makes a good point that there are two aspects, really, in a sense, that I have to overcome. One is that a finding of English law is in that grey area between being a finding of fact, because it's not DIFC law, or a finding of law. So I have to persuade the tribunal that it's appropriate for this appellate court to engage in issues of English law. But secondly, the judge himself characterized the debate before him as being an issue of pure fact because he had two experts giving conflicting evidence, but neither one of them directly rebutting the evidence of the other. So on analysis, one could say that is a finding of fact. But the reason we respectfully suggest he got it wrong is if you look at the judgment of Christopher Clark in Goshawk, can I just take you to that
Yes.
briefly? The let's find it here. You'll find it at page 2469. 2469. And the particular passage that I'd invite you to look at starts at paragraph 37 at page 2483. So Christopher Clark said this: a term may be implied in a contract if it is certain, notorious, and reasonable. See Cunliffe Owen and General Reinsurance and Fenia Patria, and the authority cited Chitty. In other words, the term has to be sufficiently clear, invariable, and well known that those who practice or seek to practice in the relevant market must be taken to know that it is implicit in the contracts that they make. And it must
Sorry,
not be...
Sorry, where are you reading from, Mr. Potts?
Sorry.
Page
so 2483 of the bundle.
Yes. Whereabouts?
At the very, very bottom. If you start at the bottom of
Right.
page
All right.
37.
Thank you.
So if you just start with a term may be implied if it's certain, notorious, and reasonable, we then go over the page. In other words, the term has to be sufficiently clear, invariable, and well known that those who practice or seek to practice in the relevant market must be taken to know that it's implicit in the contracts they make, and it must be not so lacking in reason that effect should not be given to it. If these three conditions are satisfied, it may be that the term can arise by way of a freestanding contract, but it's not sufficient to show that as a matter of practice, those concerned have often or habitually acted conformably to the term asserted. A typical way of proving the existence of a custom is to show that its existence had once been challenged, but when the challenge occurred, the application of the custom was confirmed. This is not the only way of doing so, since were that so, a term, which apart from the disputing litigant everyone recognised, would fail to be treated as a customary obligation if no one, apart from him, had ever questioned its applicability. In the present case, the evidence, in my opinion, falls considerably short of establishing a custom as opposed to a common or habitual practice. There's no evidence of an unsuccessful challenge to the custom. Mr. Berry doesn't relate any occasion when the existence or otherwise the custom was an issue. Moreover, I find it difficult to reconcile the different provisions of the codes and the draft of the Tobit to which I referred with a settled and notorious custom to the effect alleged. And at the bottom, 39, further, the difference of view of the experts appears to me inconsistent with the existence of the custom relied on. I, of course, accept the fact they hold differing views is not conclusive against the existence of such a custom, since one of them may simply be wrong. But the impression I received from the evidence of two men of great experience was not that there was a well-known customary obligation which all concerned would recognise, which Mr. Blackman for some reason did not. I do not think Mr. Berry's evidence is sufficient to elevate market practice to the stage of a freestanding contract arising by custom, and I found Mr. Blackman's evidence, having regard to breach of duty, there was no such custom obliging disclosure as relied upon convincing. And then over the page at 41, on page 2485, it seems to me, insofar as the custom relied upon obliges the broker to disclose documents to the underwriter, notwithstanding that do so would be inconsistent with the instructions or best interest of his clients, is unreasonable and not therefore enforceable. So our proposition is that what the judge has done he has simply taken one expert's assertion over the other expert's counter assertion, simply because he's concluded that the relevant market is the market in which Mr. Abdeen practices, rather than the market in which Mr. Williams practices. What he's not done is identified the legal test here properly, or considered what are the ramifications for the conclusion that in a marine war risks reinsurance contract, where there is no evidence or proof of an underlying marine peril, where the underlying policy has been avoided, so there is no longer any insurable interest in the peril, he's not explained with any degree of reason or reasoning how that can possibly be a universal, certain, and reasonable term to imply. So the judgment on this, obviously, if we go back to the judgment, it is somewhat superficial and a little bit circular. He starts the discussion at so it starts his discussion at page 112 of the bundle, at paragraph 115, under the heading insurable interest. So he recites passages from Wasser and Lexington. He then notes my submission about this not being liability insurance and there being zero insurable interest. And at paragraph 118, Mr. Craig's response was there is an insurable interest in relation to defence costs. 119, the former is a bootstrap point. It assumes what must be proved, namely the reinsurance contract extends to defence costs. We'll address that at my issue 4. So then we get to issue 4. And that that discussion starts at page 116, paragraph 130. The judge acknowledges at paragraph 130 that the issue must be determined in accordance with English law. So far, so good. But he does not go on to address the issue of English law and practice that's in the Institute clauses. He then says there were 2 pleaded bases for recovery. One was supposedly pleaded by reference to an express term, and that was abandoned at the trial. The second was implied term, it being a custom or practice in the UAE that such costs are payable by a reinsurer, particularly in circumstances where the reinsurers agreed to reinsure 100% of the risk. And that's why the judge said that trial ABNIC confined itself to the latter. So then the judge references correctly Baker and Black Sea and Baltic General Insurance, in which the House of Lords rejected that this could be an implied term as a matter of necessity or business efficacy. And paragraph 134, Lord Lloyd's endorsement of Lord Justice Millet's observation that what was needed was evidence of a universal and acknowledged practice of the market for reinsurers to pay such costs, whether it's expressly provided in the treaty or not. Or to put it another way, that is well understood by underwriters that if it is not intended the indemnity should extend to legal costs and expense of the reinsured, these need to be expressly excluded. Now, the underwriters there can only mean the reinsurance underwriters, not the underlying insurance underwriters. Then there's reference to Wasser, in which that was summarized, and a reference to the Goshawk passage I've just referred to. Then there's reference to Mr. Abdeen's evidence, and I haven't shown you all the details. I mean, we actually made an application to strike out his evidence, which the judge never even ruled upon. But he summarizes what he says his evidence was. Then he deals with Mr. Williams at paragraph 140. And you'll see at paragraph 141, he recites Mr. Williams' report, in which Mr. Williams said, I would not consider the UAE represents an established market for the reinsurance of marine war risks or reinsurance business more generally. And the judge says this was something of a surprising proposition given the existence of Auris itself and its stated objective in its financial statements. Now, as it happens, Mr. Williams in his re-examination acknowledged that one reinsurer does not make a market, but the judge sought to discount his evidence at paragraph 142 by saying he wasn't able to express an opinion on the Arab insurance or reinsurance markets. And then he went to Mr. Abdeen, who had contributed to the growth of emerging insurance markets. And despite the cross-examination challenges that were put to him, he summarized at 145 that tackle and non-tackle companies are heavily reinsured because the region is a heavy energy oil producing region, very active. The UAE is the hub in the Arab world. It's a heavily sophisticated market which seeks reinsurance. There's then a discussion of his evidence. There's a recitation of some of the points I put to him and made. He acknowledges that paragraph 156, page 124, it's fair to say that Mr. Abdi's evidence was vigorously challenged. He explained he would not produce concrete examples of other policies because they're confidential. The criticism he did not produce literature, guidelines, textbooks, publications, judgments, or arbitration awards would have had some force if it had been established that any existed and they were put to him. Just pausing there, that's completely illogical in my submission, because the point is Mr. Abdeen was trying to assert that his opinion was capable of being established by reference to illustrations, but he did not have a single document to support his opinion. He did, in fact, give examples from his own immediate experience related to the storm of April 2024, where market practice had been demonstrated. Now, that is completely irrelevant to marine reinsurance, and it was impossible to get to the bottom of that assertion absent any documents or policies.
Why do you say marine reinsurance? Because Mr. Abdeen was talking about reinsurance generally, and presumably the principle underlying the proposition that the reinsurer indemnifies the primary insurer is to encourage the primary insurer to spend money resisting liability for its own benefit, but also for the benefit of the reinsurer. Now, that's a policy that applies irrespective of whether it's marine or some other form of reinsurance, doesn't it?
Well, no, maybe I need to come back after the break tomorrow morning to deal with this or wrap it all up. But if you have liability insurance and liability reinsurance, then of course the relevant reinsurance may have defense costs coverage. And it may well be that in resisting a liability, it's in both the insurer's and the reinsurer's interest to fund defense costs.
But I'm talking about policies in which there is no express provision.
Yes.
Clearly, if there's an express provision, that covers it. But
well, I mean, here I need to remind myself and the court that we did actually rely on the fact that when you look at the institute clauses, there are in fact specific provisions that deal with financial costs, so sue and labour, disbursements, and the exclusion for any liability for any financial cause. So there are clauses that are built into the marine reinsurance that deal with it. But equally, marine reinsurance, because it's property reinsurance, the value that you are attributing to the claim is the insured value, the actual value of the ship. That's the insured amount, or in this case, the fleet. And when we look at the schedule of loss, you can see that there are fixed valued amounts that are the subject of the cover. Now, as Baker and Black Sea explains, it is not a matter of either necessity or convention, essentially, that even 100% proportionate facultative reinsurer who does stand to gain the benefit of a successful defense contributes anything towards defense costs. Those are just ordinary overheads, the cost of doing business as a insurer. So the indeterminate potential liability that would attach to any reinsurer is enormous, because you don't have any insight as to what this potential liability could be. Now, Mr. Abdeen's core point is that he's seen it in practice that reinsurers will pay, but in his experience, without offering any policy wordings to illustrate it, you should be excluding it if you don't want to pay. And my point is, if in fact in the market that he's talking about, there are just as many policies with an exclusion as there are with cover, it can't possibly be a universal market practice. It will all depend on the term of each particular policy. And now the judge's conclusion, but of course the Court of Appeal.
What's Mr. Abdeen's background? Sorry, Mr. Potts. Mr. Potts, can you just remind me in a sentence, what was Mr. Abdeen's background?
He was currently a
I thought
CEO.
it was something to do with AIG.
He had worked
Of
in
AIG, wasn't he?
He had worked with AIG in an executive capacity with AIG. He was not himself a marine underwriter. So his report, you can find his report.
Yes.
It starts at page. Sorry.
I've got his report somewhere. I can find it.
Sorry, his report is at page 738. Page 738. And you'll see his background is discussed at page 741.
Thank you.
His current position was as a CEO of Abu Dhabi National Takaful. So it's a Takaful provider, not a commercial insurance provider. Now, I mean, time doesn't permit now for me to make every criticism of this report that we made in the court below. But you will see that his assertion was, for example, at 3.1.7, at page 744, that it's a uniformly accepted market custom in the reinsurance market, whether facultative or treaty, in the UAE and Middle East, that in the event of a claim under an underlying policy, any litigation fees incurred by a reinsured will be reimbursed by reinsurance in accordance with their shares. In this regard, unless they are expressly excluded or limited by a reinsurer, then in my experience, such fees form an integral part of the reinsured's reinsurance claim. And this led him to a conclusion, which is at page 749, which is at paragraph 4.1. He asserted that ABNIC is entitled to be indemnified by ARIS under the reinsurance contract on a 100% basis for all the litigation fees and expenses incurred during the process of defending the claim submitted by Horizon, which includes the reasonable necessary steps to protect both ABNIC's position and that of ARIS. Such steps were taken ultimately for the benefit of ARIS, who had assumed 100% of the risk under the underlying policy. Now, just pausing there, the hull policy, which was the subject of the underlying litigation as well, and which was avoided as well, we don't reinsure. That has completely separate reinsurers dealing with the hull policy. So the logic of Mr. Abnick's bizarre conclusion there would actually have to be that every one of the reinsurers should contribute pro rata according to their share. But it's not a workable implied term. It's not a reasonable implied term in circumstances where we're there to reinsure the vessels. And
the claim was under both hull and war risks policies, was it?
Yes. So the Horizon, the ship owner, it could never establish whether the ship was lost by a marine peril or a war risk. And so it threatened claims under both the hull policy and the war policy. And when ABNIC went to the DIFC court, to Justice French, for a declaration of non-liability, they sought to avoid both the hull policy and the war policy. But the hull policy has a completely different group of reinsurers whose identities have never been disclosed to us. So what Mr. Abdeen could not explain is how the war risks reinsurer, despite there not being any established marine war risk peril, and despite only being one reinsurer of many, how could we be liable for 100% of the defense costs? And you can. I'll have to come back to you tomorrow on this, I think, because I don't want to take the court beyond its sitting time. But
we've got till well, we're supposed to sit for 4 hours. We took 20-minute break, so we've got about another 10 minutes. Mr.
Okay.
Potts.
Clearly that there is a unquantifiable potential liability on behalf of every reinsurer if Mr. Abdeen is correct. But even if Mr. Abdeen's anecdotal suggestion that he's seen it before, without corroborating that with any documents, even if that's correct, his actual position is it all depends on the contract. It depends on whether it's covered or not. It depends on when it's excluded or not. And if you want to exclude it, you can exclude it. As soon as you...
So I thought his evidence was that the practice is there, but you can exclude it. He wasn't talking about contracts in which... Did he say that there are contracts in which it's expressly included as well, did he?
So if you can look at page 746 of the bundle.
Yes.
He says, departing from market practice, of course, there are situations where parties to a reinsurance contract may wish to depart from this market practice. In my experience, this is done as follows. If a reinsurer wishes to avoid reimbursing litigation fees entirely, then I'd expect specific language to be included in the applicable cover note slip. If a reinsurer wishes to limit the amount payable in respect to litigation fees, I'd expect specific language to this effect and a specific sublimit to be included. Or if a reinsurer wishes to monitor or participate more actively in control of the defence of the claim, then I'd expect the reinsurer to insist on including commonly used internationally recognised clauses such as claims control or claims cooperation clauses to give it this entitlement. In this regard, some reinsurers impose these clauses to make sure they're in control of the defence process, their expenses associated therein, to give them an opportunity to approve the incurrence of such costs in advance.
Well, that's rather what I thought. So what he's saying is that in the absence of any provision, there is an obligation to reimburse defence costs, but you can limit it in the 3 ways he sets out in the clause you've taken us to.
That's what he seems to be saying here. But the point I'm trying to make to the court is that that is not evidence on proper analysis of a universal, notorious, and reasonable practice in the relevant market. Instead,
but isn't the thrust of his evidence that unless you restrain it, then the universal practice is that you pay?
That's the thrust of what he was saying. If you assume that he has the relevant expertise and is doing more than just asserting his bare opinion, that's what he's saying. But the problem is when you actually look at the marine war risks reinsurance contract in this case, and when you look at the institute clauses and you look at the schedules of value, the first question is it within the scope of cover? And the defence costs are not within the scope of cover. So if they're not within the scope of cover, you don't have anything to exclude. If anything, they are excluded because there's a clause that I showed you a bit earlier that excludes liability for any financial cause. So there's an inconsistency between this implied term and the express terms of the reinsurance. Now, it may be that what I need to do is explain to you the logic of the Baker and Black Sea case and also the judgment of Mr. Justice Simon in the...
Speaking for myself, what would really help me, especially if you're coming back to this, you've dwelt quite a bit on what you say are the weaknesses of Mr. Abdeen's evidence. But this is a point where we're speaking again for myself, one is acutely alive to the advantages the judge has. And what would really interest me is if you could focus on why and how, if we were otherwise minded to do so, we should depart from the judge's decision. That can't be because of the weight he gave to one party's evidence. There need to be some discrete points which, if they're open to you, entitle us to take a different view.
I fully accept that. I apologize. So
the fact that we might have taken a different view had we been the trial court doesn't really get you home.
No, but the grounds of our appeal, if I can just try and focus on that, then the first ground is that the judge was wrong to conclude that it's possible to have a defence costs liability in the absence of there being an underlying insurable interest. So once the war policy is void ab initio, there isn't there an insurable interest to reinsure. And it does, in my submission, follow as a matter of law that the reinsurance contract is necessarily void if the war policy is void. Now, the judge didn't accept that because he formed the view that if there was an insurable interest in some unquantified defence costs, that somehow survived the avoidance of the war policy. The next difficulty, though, for the judge in my submission is that if you...
Sorry, just pausing there. The defence costs were incurred establishing that the underlying policy was void.
Well,
so it can't, surely it can't be, you couldn't imply a term to the effect that you get costs, but only if you fail. So in other words, it would seem perverse because the purpose of incurring these costs before Justice French was to establish that the underlying policy was void. So it's entirely inconsistent with the term implied to deny recovery of costs, because otherwise no insurer would bother doing that. They just pass the bill on to the reinsurer. That's why I'm having a lot of trouble with your constant reference to the voidness of the contract as completely destroying the reinsurance policy. It just seems to me to be a bit problematic. But
well, I don't want to. Maybe I have to refine my final points tomorrow morning. But
can I add my voice to that? I find that problematic both generally and in particular in this context for the very reasons the Chief Justice just given. There would seem on the face of it a perfectly reasonable argument for saying that if you incur costs avoiding a policy, you might be entitled to recover. And there's a good reason for that, to incentivize doing so. So as a basis for your argument, I too struggle with that.
But there are, in a sense, two separate issues, if I've understood this correctly. There's a question of whether there should be an implied term as a matter of necessity or business efficacy as a matter of law. And the commercial arguments, one way or the other, have been settled by the House of Lords that there isn't such an implied term as a matter of necessity or of efficacy. So it's just tough luck, essentially, for an insurer, whether they defend the claim and win or they defend the claim and lose. The cost of defending an insurance claim is part of the ordinary course of business and the overhead of an insurer. And it does not matter.
That's the position in London. Sorry, Mr. Potts. I mean, the issue we're grappling with, which got us down this road, is the judge has found on the evidence that there is a market for reinsurance in the Middle East, and he has accepted the evidence of Mr. Abdeen to the effect that it is the custom in that market for reinsurers to pay defence costs. Now, the question Sir Peter posed was, how do we? What is the error of principle? What is the failure to take into account a relevant consideration or the taking into account of a relevant consideration that entitles us to interfere with that decision, given that he saw and heard both witnesses?
When you look at our grounds of appeal, we have one ground which is focused on the absence of an insurable interest once the war policy is voided. We have another ground which says you can't have cover of any sort if there's not, in fact, a marine war risk. If you can't establish there's a marine war risk, why should a marine war risk reinsurer pay anything?
Well, the answer to that is exactly the same as the answer to the lack of insurable interest. It may be in the reinsurer's interest to establish that there is no war risk. So in other words, the primary level insurer who goes to court and establishes that the loss of the vessel was not due to war risk would be shooting himself in the foot, and not, whereas in fact what he's doing is protecting the reinsurer.
Well,
so both of those propositions, it seems to me, run counter to the policy which would underpin the implied term.
If I may, I'll have to come back to you probably tomorrow morning on those particular points. But to wrap up, Mr. Abdeen, in our grounds of appeal and our skeleton argument, the core complaint is that without critically analysing Mr. Abdeen's evidence as to whether it demonstrated universal market practice in a relevant recognised market, essentially all the judge has done is accepted one person's opinion in circumstances where, as a matter of English law, this is not an implied term that you would ordinarily expect to find in a marine war risk reinsurance contract. And to suggest the burden is on the reinsurer to have excluded it is irrational because it's not within the cover. But this is dealt with in our grounds and our written submission. I mean, I fully accept the judge himself has tried to make the judgment appellate proof, because what he's tried to do is he say, look, this is an unfortunate case where I didn't have two Middle Eastern experts before me. I had one expert of English market practice who said this is not an implied term in England. I accept that, he says, effectively. But the relevant market is the Middle East. And I've got this other gentleman who tells me it's universal or common in the Middle East. Now, when you analyze that critically and you look at Mr. Williams' evidence, as well as Baker in Black Sea and Wasser in Lexington, you will come to understand in my submission why this is an illogical term to imply in a valued marine policy.
Well, I think we should probably adjourn now, but I must say, Mr. Potts, I'm having trouble seeing how those submissions aren't just saying the judge got it wrong on the evidence. And that's a problem for a court of appeal. But why don't you think about it overnight and come back? What I think Sir Peter and I, at least, and possibly Justice Keane as well, would be very interested in is what are the errors of principle that could justify overturning the decision on this point. But that's some homework for you. We've given Mr. Craig some homework to do. Shall we adjourn now and resume tomorrow at the same time as we started today, unless there's anything else? No?
If it helps, right, on one answer to my homework in relation to the UAE position on the implied term, which I don't think will arise. I hope it doesn't arise, but to the extent it does, if I can just give you the reference to the closing submissions that I made. It's at page 1882 of the bundle. It's day 4 of the transcript, and it runs from page 63, line 16 to lines 65, line 10. And it is also contained in my skeleton argument before the hearing at page 1644.
Thank you. So what were those lines again? Page 63, line 19, was it?
Line 16 to page 65, line 10.
Yeah. Right. Thank you. And page 1644 in the skeleton.
Yes.
Thank you. All right. Well, we're all in different time zones, but we will resume tomorrow at the same time as we started today, and we'll adjourn until then. Thank you, everybody.
Thank you very much.
Yes.